Everybody, I'd like to call to order the City of West Palm Beach Code Enforcement Special Magistrate Agenda. Today's July 7th, 2021. My name is Keith Davis. I'm the Special Magistrate appointed by the city to preside over today's agenda. If you'll please silence your cell phones so they don't interrupt our proceedings, that will be appreciated. And then, if you're going to be speaking to me today about any of the matters on our agenda, your testimony needs to be under oath, so I need to swear you in. If you fall into that category of person, if you'll please stand and raise your right hand. Only your right hand is necessary, and I will swear everybody in together. Do each of you swear or affirm under penalties of perjury that your testimony today will be the truth, the whole truth, and nothing but the truth? Thank you very much. You can have a seat. We've got a pretty big agenda today. I think, as usual, we'll be starting with the construction service cases and then going in the order that folks signed up to have their case heard. When your case is called, if you'll please come up to the podium to my right. The way we'll proceed with each case is I'll hear from the city's witness or witnesses first. They will tell me about the case. There may be documents and photographs that will appear on the monitors. You'll have an opportunity to look at those. Once the city's presented its case and made any recommendations for a resolution, you'll have an opportunity to ask questions of the city's witnesses. You'll have an opportunity to also tell me about the case from your point of view. If you have additional documents or photographs that you want me to look at and consider, that will be the time to produce those. Once I've heard everything from everyone, I will, in all likelihood today, enter an order that resolves the matter. So that is how we'll proceed, and without further ado, let's go ahead and call the first case.
Matter number 1, case number CE 2010-0304, case address 511 Malvern Road.
Morning, sir.
Ms. Dan?
Morning.
Dan Kempa.
We're going to need to recall the case as the building inspector official is not here yet.
Okay. Let's try again.
Morning, sir.
We'll be right back to yours.
Matter number 2, case number CE 2105-0150, case address 702 Forest Hill Boulevard.
Good morning.
Good morning, sir.
Whenever you're ready, you can.
Okay, this is a case of a homeowner that pulled an original fence permit for 3 sides of his property. And the company that did the installation added some pieces and encroached into the rear neighbor's fence, and he was not happy, so he complained. We subsequently asked the neighbor to remove it. He proceeded to remove and then added an extra piece of fence that was not on the original permit.
Okay.
So then we issued a stop work order to get a plan review or an extended on another permit for the additional piece of fence.
Okay.
Now, since then, we have given him several extensions, and on the last one, he did apply for the permit for the extra extension, so we are going to give him 60 extra days to comply and get the permits and call for his inspections.
All right, so permit's been applied for at this point. It's in review.
Yes, it's in
60
plan review.
days. Is there a daily fine that you're recommending, $100 a day?
I
50 a
mean,
day? You tell me what.
I would, at this point, I would leave it up to
Okay,
you.
that's fine. And it looked like while you were testifying, I did see that the city got notice of today's hearing by certified mail. Is there anybody here on behalf of the respondent? There is not, but with the certified mail, the city has proper notice. Based on the testimony and the evidence that I've reviewed, I do find the property remains in violation as cited. I will allow an additional 60 days for the violations to be complied. Thereafter, daily fines of $50 per day will be assessed until compliance is achieved. Thank you.
Matter number 3, case number CE 2105-0091, case address 5511 Greenwood Avenue.
Good morning.
Morning.
I'm Tim Large, Chief Plumbing Inspector for the City of West Palm Beach. This property was initially cited on May 6 for the installation of 2 backflow prevention devices without the benefit of permit or inspections. We received proper notice by posting of the property on June 7th of this year. To date, no permits have been applied for the backflow prevention devices. The city's requesting that the applicant be given 30 days to obtain all permits or face a $50 a day fine.
$30 days, $50 a day after that.
Yes, sir.
All right, looks like you tried with the certified mail, but were unsuccessful, and then you posted.
At the time, it says there was, certified mail was in transit, have not had any results in the folder as yet.
Is there anybody here on behalf of the respondent for this case? All right, with the failed certified mail and the posting, I will find proper notice in this case. You said there were 2 backflow preventers, is that,
Yes, sir.
looks like there's 3 in the picture.
There are, but the other 2, it's the 2 center ones that haven't been permitted. The 2 outer ones have been permitted.
Okay,
And these permits, we usually turn around in about 3 days, 2 to 3 days, so it's an easy thing for the owner to do.
okay. Yeah, there's actually 4, I didn't even see the great big one over there. Okay, then based on that testimony and evidence, I do find property remains in violation as cited. I will allow 30 additional days to comply. Thereafter, daily fines of $50 per day will be assessed until compliance is achieved.
Thank you, sir.
Thank you.
Is Dan here yet? No, okay. Matter number 48, case number CE 21050353, case address 917 39th Street.
Morning.
Good morning.
Give me one, I'm so sorry, give me 1 second.
Oh. What I have to say? What I have to say?
The special magistrate will speak to you in a moment.
I'm so sorry about that.
That's okay.
Natalie Clark, City of West Palm Beach Code Enforcement. 917 39th Street was cited on 5/25/21. The property was posted on 5/27/21 and certified mail was sent on 5/28/21. The property was cited for 18-162A, 22-32A, 34-102B, and 94442C1, 94442E, and 94-485A. The property has since complied with 34-102B and 94-485A. I've had no contact with the owner. The city is asking for an additional 30 days or $200 per day until compliance is achieved.
Natalie, how do you know it's being rented?
Basically, the neighbors complained that it's a rental, and they're doing mechanical work, and that's pretty much why it was cited.
And how recently did the neighbors make that complaint?
It was you said recently?
How recently, approximately? How long ago?
It was a couple days prior to the property being cited.
Okay, thank you.
All right, anything else from the city at this time?
No.
All right, yes, let me get some information from the respondent. Good morning, ma'am. If you could tell me your name and address, and then you can tell me about the case.
Solange Michelle. The address is 917 West 20,
Yes, ma'am, go ahead.
917 39th Street, West
Yes,
Palm
go
Beach.
ahead.
The, my mom stay in a house and she passed away, and I do have the letters. She used to take care of the house, and it's my brother and my sister stay in the house. So after she passed away, and it was no take care at the time because it was no job, and I had to make sure to bury her. And at the same time, at the same month, that's when everything was happening.
Is anybody staying in the house
My
now?
brother and my sister.
Are you renting the house to tenants?
No, I was in there, and I have my own house, and I leave it because I bought the house for her. And there's her children, so if she passed away now, I cannot put them out.
Okay. So the children are still there, and did you say
Yes.
you're staying there now too?
Yes.
Okay, and how long has that, when did she pass away? How long have you been?
She passed away in I have the letter, 2 months ago.
2 months ago?
Yeah. And she used to take care of the house well good, and it was nothing, no issues was there. And I don't have no money I just bury her.
Before, how long had that living arrangement been going on?
Say it again.
How long had she been, before she passed away? How long was
She
her?
was in hospital for almost good 6 months, doing corona. She was there for 6 months. And I did 6 months, I have to go back and forth from Miami. She was not here, she was Miami. So basically, I would not keep her in the house. I would just focus on her from the hospital. So,
Was there ever a time that you were renting the property, collecting rent,
no.
that you had tenants?
No, as my mom been living, I bought the house 2017. The 2017, I bought the house, and since she been staying in the house, it was a gift for me to my mother.
Okay.
Magistrate, it is listed under an LLC with a different mailing address. I have cited the property before, I think in 2018. And at the time, I did speak to a gentleman that didn't say they were like a relative, because the property was cited for kind of like the same issue with the mechanical work. But at that time, I think it was just under the name, not an LLC, so I couldn't prove then that it was a rental. But it is under an LLC now with the different
Yes, it
mailing
is.
address.
Yes, it is.
It is.
Okay.
Yes.
I think the fact that the property is owned under a corporate or an LLC isn't definitive of a rental situation. So let me come back to the city. Tell me how you made a determination that this was a rental property.
So the neighbor complained about the issues with it, and the neighbor was the one that made the complaint that there are tenants there and they're using it as a mechanical repair shop, and that's when it was cited.
Okay, I get, clearly the pictures are very clear in terms of the landscaping and the inoperative vehicle and the mechanical work. That's very clear. I guess what I'm having difficulty with is the use of the property as a rental.
So, I mean, like I said, I just went off of the neighbors complained that when I cited it before, it was kind of the same thing where the neighbors were like, the tenants are doing mechanical work. Again, I didn't speak to anyone there, but at that time, it
You
wasn't
don't have the
cited.
neighbor here this morning?
No, I don't.
All right.
Natalie, has she filed an affidavit of non-rental?
No. So the affidavit of non-rental hasn't been completed either, so. That would be one option, to either apply for the rental tax or to complete the affidavit of non-rental, and that wasn't submitted to the city.
Okay, well, and I'm happy for you to advise her that she can do that. Ma'am, is there anything else that you'd like to tell me?
Well, That's my first time here. I don't know what to do. The only thing my brother was there, so basically he did tell me he was fixing the car, but I don't know what he was. It's a young guy, so I don't know what he was doing. So he's not there no more. Like I told him, you gotta trust is you live there or you not live there. So he gone.
Well, Ms. Clark has testified that although that was a problem when she cited the case, it has complied, so that's no longer happening.
Okay.
But you still have the landscaping issues that you need to deal with. So, and I'm happy to give you the 30 days to fix that.
Well, can I have a little bit more? Because I'm really just, I don't even pay my tax yet. It's just like, I just got back to work last week and I have to work at least 3 weeks to get paid. So I'm really like
How
under
much time are you asking for, you tell me?
Whatever you can give me.
I beg your pardon?
Whatever you can give me.
Okay.
Please.
Okay. All right, here's what I'm gonna,
Magistrate Davis, would you indulge me that I ask the respondent just a couple more questions?
you may.
Okay. Ma'am, do you maintain a separate residence besides this one?
Just mine.
And you mentioned that was in Miami?
No, my mother was in a hospital in Miami.
Okay. So besides this residence, do you have another property?
Yes, I do.
Okay. And does this one have a homestead on it?
Yes, ma'am. I stay on, that's my house.
Okay. You mentioned that your brother stayed there and that your sister stayed there and that your mother stayed there. At any time, were they paying the utility bills?
I pay them. I pay my water bill and my utility bill.
Okay.
Everything
And,
is in my name.
and at any time, did they pay you any type of rent or other type of assistance because you allowed them to stay there?
Well, I was not allowed my mother to pay because it was a gift. I was a gift for me. So I was just giving, I was bought the house to give it to her.
Thank you.
My pleasure.
Anything else from the city?
Special Magistrate, it does not appear that the residence that we're speaking of is homesteaded from what I can see. Can you, can you scroll down? Thank you.
I mean, here's my problem. The only evidence the city has of a rental is a comment from a witness who's not present. I'm not willing to find that violation based on what I've got this morning. So I'm not going to find that in violation. If the city gets more evidence and wants to bring a new case, that's fine, ma'am. There's a mechanism that the city has where you can swear out an affidavit that you're not renting the property. You might want to speak to the appropriate people at City Hall about doing that if you feel that that's appropriate. I am going to find the property to be in violation of City Code Sections 94-442C1 and 94-442E. I'm going to give you 60 days to cure those violations. If they're not cured within the 60 days, though, there will be daily fines of $50 per day until the compliance is achieved.
Yes,
I
sir.
find the property, based on the testimony and the evidence, has complied with 34102B and 94485A and is not in violation of 18162A or 2232A. Okay, thank you very much.
Thank you, sir.
Ma'am, you have another case. 1 second. Natalie. Matter number 51, CE 2105-0360, 830 43rd Street. It's not your property? 830 43rd Street. That's your property? Yeah, okay, you can stay at the podium then.
Good morning, Natalie Clark, City of West Palm Beach Code Enforcement. 830 43rd Street was cited on 5/25/21. The property was posted on 5/27/21 and certified mail was sent on 5/27/21. The property was cited for 18-162A, 22-32A, 74-4B, and 94-442C1. The property has since complied with 74-4-B and 94-442C1. I've had no contact with the owner, same owner. The city is asking for a split order for Code Section 9471C. The city is asking for 10 days or $50 per day, and for 18-162A and 22-32A, the city is asking for 30 days or $200 per day until compliance is achieved.
And
So
I'm
it's,
sorry, and just before you go on, I had, can you tell me again what you're asking for the 9471?
10 days or $50 per
10
day.
and 50. Thank you. Go ahead.
What's going on in the house?
And again, it's the same owner, different property.
Okay, let's hear from Ms. Solange again. Go ahead. Go ahead and, just for the record though, ma'am, go ahead and put your name and address on the record.
Solange Michelle?
Thank you. Go ahead, and go ahead and then the address for this one is 830 43rd Street.
Yeah, I never heard nothing about it.
Okay.
She said she tried to contact me.
Pardon me?
She said she tried to contact me.
I don't understand what you're,
She said she tried to call me, something like that.
No, ma'am. I said the property was posted.
Posted?
Yes.
What's posted mean?
The notice was posted at the property.
Nobody never said nothing.
Ms. Clark testified how the city provided notice of today's hearing. Obviously, you got it because you're here, and there's a photograph of the posting. And she also testified that she's had no prior contact with you before
Was she
about the
ne-
case. So if you have questions of Ms. Clark, you can ask them. Otherwise, you can tell me about the case.
I don't know, that's my first time heard it. That's my first time know I have a notice there. She never told me it's a notice there.
Can you pull up the pop-up, please?
The certified mail was returned or unclaimed?
Who was it returned by? Just 1 second. Okay, so the mailing address on file is the same mailing address for the previous case.
Okay.
So it was sent to that
Okay.
same address.
Was it received or was it returned? I just want to get the record clear on that. Okay. Well, I mean, so certified mail was returned.
Yes.
There's evidence the property was posted and the respondent is present, so I am going to find proper notice in this case. So let's go ahead and talk about the actual violations. So whatever you'd like to tell me about the case, ma'am.
You talking about the grass? I don't know nothing about it. It's the grass.
So it was cited for the appliances that was out on the front lawn, for all of the outdoor storage in the carport, for the landscape maintenance, and for the rental tax. So those are the violations.
Only thing it was enough, a car was parking there. The car is walking. So I see her have a refrigerator in front of it. That's it. There's nothing in there, and she got plant on it, and there's nothing in there. And the refrigerator is right in the car porch. It's not outside. Only way you can go, you have to get in there, get out of the car, and walk to the house, and go in there and look for things.
No, you can see them from the street right there.
Yeah, but you have to get out of the car and you have to walk in there.
No, ma'am, you can see it from the
So basically, I don't know nothing about it. I don't have no letter. I don't have no call. I do have a letter for 9/17, but I do not have no letter for this.
All right, well, Ms. Clark, did you say the landscape issue has been
That one
complied?
was, yes, the one
So
for
really,
the
we have the
bulkhead,
outdoor storage, and then the rental issue is what's left.
those are the only ones outstanding.
Okay. All right, is there anything else you'd like to tell me, ma'am?
No, sir.
Okay. Well, in this case, then, based on the testimony and the evidence, I will find the property remains in violation as cited, except it has complied with 74-4-B regarding bulk goods and on the lawn and in the carport, and regarding 94-442-C1 regarding landscaped areas being in violation. All the other violations remain. I will accept the city's recommendation in this case. I'll enter a split order on the outdoor storage violation. I'll give you 10 days to comply with that. After that, there will be daily fines of $50 per day. On the rental and certificate of use, I'll give you 30 days to comply with those violations, or there will be $200 per day assessed until compliance is achieved. Okay?
Thank you.
Thank you very much.
Ma'am, we're going to mail those orders out to you, okay?
Excuse me. You got my right address? The address? Yes, ma'am. Thank you.
Matter number 1, case number CE 20100304, case address 511 Malvern Road.
Good morning.
Good morning.
I'm Philip Petty, Chief Electrical Inspector for the City of West Palm Beach,
Yes, sir.
standing in for Dan Kempa, who's absent without leave. Yeah.
Uh-oh.
I just checked up on the permit. He's paid all the fees. He's got the application in. Everything's fine. It's going through zoning at the moment. So I'd really like to give him like a 60-day extension because it's still got to go through zoning. We'll issue the permit, do the inspection. It's a fence.
Oh, were you here when I swore everybody in this morning, sir?
No,
Let me go ahead and place you under oath, and then I'll have you give me the case again. Do you swear or affirm under penalties of perjury your testimony today will be the truth, the whole truth, and nothing but the truth?
yes, sir.
Thank you. Go ahead and,
I'm Philip Petty, Chief Electrical Inspector for the City of West Palm Beach, standing in for Dan Kempa.
Do you have the information regarding the notice of violation, stop work orders,
The survey.
surveying? Well,
This is just a permit application that shows that they've done everything they needed to do.
I would recommend if you don't have any, service,
Who's got the folder?
Dan, that you rescheduled,
No, probably our girl Kathleen.
that you rescheduled.
Can we continue this later? I need to go get the folder to show service, if that's necessary.
I'll give one more try. I know the gentleman's been here.
I'm sorry, I didn't
so-
know.
No, I want,
Is he
but
here?
Are you the respondent, sir?
Yes, sir.
Yeah, so, get what you need and,
Give me a
and,
couple minutes to go get the folder. It's in the, across the street. I'm sorry.
Excuse me, sir.
go ahead, but I want to, as soon as you're back, I want to recall this and get you on your way, so.
Matter number 63, case number CE 21040320, case address 2914 Washington Road.
Good morning.
Morning.
Sonia Bin, City of West Palm Beach, Code Enforcement. This property was cited on April 15. Property was posted on April 21st. Certified mail was sent on April 19. The property was cited for code cases 94451D, 94442C1, and 94451A. I have not made contact with the property owner, and the property is still in violations of all code cases 94451D, 94442C1, and 94451A. The city is requesting an additional 60 days to gain compliance, or $100 per day until compliance is achieved.
Okay. Counselor,
Hi. Good
state
morning.
your appearance on the record
Yes, Greg Kine, for the record, I've been sworn in.
with both
Not
hands.
sworn at yet, so, thank you, city staff. And the reason I didn't communicate with you directly, I'm sorry, apologize that, we've been having some discussions at, a higher level, on this matter. This is the artificial turf case, that's been, I think you've heard from some other, residents have been cited for the same regulations. But
Indeed.
as of July 1st, a work session has been scheduled, and I have a memo.
Magistrate, I apologize. Did he state his name?
Greg Kino.
I'm sorry?
Yeah, Greg Kino.
Okay.
And does the city have a copy of this?
Yeah, I'll
No.
give you a copy.
Give that to the city
This
attorney.
is,
Go ahead and give,
Greg Kino again, for the record, 515 North Flagler Drive. As of July 1st, the city administrator, at the behalf of, or at the request of several city commissioners, has set a city work session on August 2nd on this matter to take up a potential code change. Right now, artificial turf is allowed in the side and rear yards, but not allowed in the front. And they're going to take up that matter to see if that would be appropriate to extend it to the front yards. I have spoken to the majority of the commissioners, and I'm confident that that's going to occur, but time will tell. One thing I should note for the record is that while certainly this falls under public safety, health, and welfare, I don't believe it's a real pressing matter, as opposed to, some real threat to the public safety. I think the grass looks great, and you'll probably be it would be difficult for you to tell the artificial turf versus the regular turf in those pictures that they're both depicted. So I would like to extend, if I could, the hearing date, because if we give a compliance date and it's moving forward, I doubt the code would get changed by that time, just because of the public hearing requirements and notice. So what I'd like to do is continue it for the 60 days, although if in on August 2nd, I think we'll get a flavor of where they're going to head on this. And if it doesn't move forward, we'll come back and we'll agree to an appropriate compliance date that would be fairly short. But this is very expensive, turf. They both use licensed contractors. I have another case that's similar. And I would make the same arguments for that one as well, which is 280 Edgewood. So we just respectfully request if you can continue it, and we'll see where it goes. And then I'll come back here, and we'll either have a good idea that it's going to move forward, or we'll set a hard and fast compliance date, and they'll have to take care of it if the commission's not going to provide some relief. But they did both use licensed contractors, and it's not a real threat to the safety.
okay.
Special magistrate, I understand, his argument, and while the artificial turf may look good or not be what he considers any health, safety, welfare issue or priority, I think the issue turns on, these are what our ordinances require now, and just because a work session is scheduled, it doesn't mean that the ordinance is going to change. Our administration has indicated that cases should move forward, inequality against everybody, as opposed to putting off cases. Again, we don't know what'll happen coming out of the work session. It could be that this doesn't change at all. It could be that there's more work sessions. It could be that there's more planning, contemplation. This could be months and months and months. So the city would respectfully disagree with the argument and would indicate that, just as in all of our other artificial turf cases, there is a date certain to bring the property into compliance with a fine of a daily nature after a certain amount of time if the property is not brought into compliance. Now, the city can certainly, come to a proposal in terms of whether that might be, 60-day deadline for that, or, something even, a little bit more reasonable. But it's a deadline and not an extension to bring the case back to see where the work session is. because we've brought all the other turf cases, and everybody else under those cases has had to go through the same procedure.
Your Honor, if I may, first of all, there is a July 1st, which is fairly timely, memo from City Administrator. I don't see that in there to that effect, that all cases should move forward and fines imposed. And additionally, the turf in the both cases that I have been in for, so one of them has been in for at least 2 or 3 years, and actually they got their certificate of occupancy was held up until they put landscaping in, and the turf was in when it got its CO, and they were never told that they had to get a building permit or it wasn't permitted in the front yard. So as far as any pressing time considerations, respectfully, I don't see that being a real urgency. Some of these other cases have been in for years. So in the scope of things, the whole scope of things, this a few months potentially, and I think we'll know quickly if come August 2nd, if the work session, there's really no support, and they tell staff we don't want to do it, and I think we'll know, and we can set a hard and fast compliance date. But what we don't want to have happen is forcing somebody to rip out expensive and very aesthetically pleasing turf because of some artificial date, and no pun intended. And then the commission goes ahead and approves the change to the front yard, and they've ripped it out and have to put in regular grass, and then they could have kept it. So that's what we're talking about. We're not talking about it. I'm not asking for a year, but I think we'll know fairly shortly. And I just hate to see them forced to, at the threat of a fine, rip out the turf and it gets approved.
Okay.
Briefly in response, it's not a question of how long this turf has been there. It's a question of the notice of violation was sent out and proper notice was given per the statute. It's a time period from that time period.
Okay. So here's what I'm going to do. First of all, I do find proper notice. Respondent is present through counsel. I am going to make a finding that the property is in violation of city code. The city's recommendation was a 60-day compliance window. I'm not going to enter an order that sets a compliance deadline or daily fines at this point. I would like to see this back on my August 4th agenda, which is 2 days after the August 2nd workshop. Now, and I'd like to hear what happens at that workshop. If there's sufficient evidence in my mind that there's not going to be relief at the city commission level, then I will impose a compliance deadline with daily fines at that time. I think that's well within the 60 days that the city was recommending anyway, so I don't see that anybody's really harmed by doing it that way. So I do make a finding of violation. I'm not going to impose a deadline or daily fines pending what I hear at my August 4th hearing on this matter and what happens between now and then.
Okay.
Okay?
Special Magistrate, I just want to put on the record the objection,
Understood.
just for the record.
Understood. And I will just say, and I understand this is not the first artificial turf case I've seen in the recent past. This probably won't be the last, but this is the first one that I've had where I've been presented with evidence that there is definitive intent at the city commission level to discuss it. So I'm willing to, within the 60 days the city was recommending, I'm willing to give the benefit of the doubt to the respondent on that, see what happens, and then depending on where we are on August 4th, we'll go from there.
All right.
Okay, thank you.
Magistrate, can I ask a question on that?
Beg your pardon?
Can I ask a question on that?
Sure.
Okay. There's no guarantee that anything is going to change. If the August 2nd workshop is,
Correct.
okay, we're going to look at this further, are we going to keep extending these?
I don't know. I'll see what I get on August 4th.
I mean, we can only operate with the code as is, not with the possibility of a code changing in the future.
I can't tell you what I'm going to do on the 4th until I hear what
Okay.
what happens between now and then.
Special Magistrate, I think this is the same case as number 67. Do you want me to call it, just for the record? It was the same
That probably would be
violations.
a good use of our time, yeah.
Matter number 67, case number CE 21040339, case address 280 Edgewood Drive.
Mr. Kino, you are on that case as well?
Yes, Greg Kine for the record, 515 North Flagler Drive. I do represent Jared and Linda Soper.
Let me go ahead and let the city put the case on the record, and then,
Yes, thank you. Sonny Bin, City of West Palm Beach, Code Enforcement. This property was cited on April 15. It was posted on April 20th, and certified mail was sent on April 16. The property was cited for code cases 94442C1, 94551A, and 94551D. I have not made contact with the property owner, and the property is still in violation for all code cases. The city is requesting an additional 60 days to gain compliance, or $100 per day until compliance is achieved.
all right, Mr. Kino?
Yeah, on this particular case, there are two extenuating circumstances, and I'm prepared to, but I wasn't going to get into defense of the case in the light of the fact that I think that there's great anticipation of a code change that would allow this as well, both in the fact that this may not technically be the front yard, or at least portion of it may not be, and the other issue in this case is that they were required to get a certificate of occupancy after extensive renovations, and they put this turf in with using a licensed contractor, and the city signed off on that CO. So I really didn't want to get in the merits of that at this juncture, and would kind of want this to kind of track the other one. I can say that we'll have a resolution of this one shortly as well, either because it's not in violation because of those two issues, which I really had not pursuing because I think a code change will occur and correct this. So I do want to make a reservation of rights on those two issues in the event that the code case doesn't move forward. But I believe even if I do go down that road, that it will be resolved at a staff level, and there'll be testimony in front of you that supports those positions.
Okay, and let me ask the city a question. The photograph I'm looking at right now and the photograph I'm looking at right now, were those both taken from the street?
Yes.
Okay. Okay. All right, then again, I find proper notice, respondent is present, represented by counsel. Based on the testimony and the evidence, I do find the property is in violation as cited, but I am going to continue any further ruling or order until my August 4th agenda, which is after the August 2nd scheduled workshop.
Okay.
Thank you.
Thank you.
Special magistrate just making the objection for the record.
Thank you, understood.
Matter number 1, case number CE 20100304, case address 511 Malvern Road.
Okay, third time's charm.
Good morning.
Yes, sir.
Philip Petty, Chief Electrical Inspector for the City of West Palm. I'd like to apologize for my prior confusion. I
No
thought
problem.
this was already set up. I went and got the file, read it all up. It does seem like there might be a minor error on the file, but since the gentleman's already here, I think we should continue.
All right,
That's
go
okay.
ahead. So,
So when was the stop work order?
It all began with a stop work order on 6/20 of 20
With regard to what?
with a fence permit
And is that the
by
fence?
Dan Kempa.
Is that the fence? Is there an indication of a fence?
No, there's not a picture.
Okay,
Monique, that's not the right address.
The 511 Malvern Road.
then
We had,
was a notice of violation. done?
yeah, we had it posted on 6/21 of 21, and we sent certified mail on 6/16 and got service on 6/21.
Okay. And then what occurred since then?
Since then, they've paid for the permit, and the permit's still in zoning before it can get approved.
So does that mean that the permit has not actually been issued?
Right, the permit is not issued, but it's in for zoning to see if we can
So does that mean that they've done the fence or installed or
No,
done something that they're not supposed to
yes,
before getting the
but
permit?
we're moving toward it.
I'm sorry,
It's
say
gotta
that
go-
last
It's
piece
got to go
again.
through the zoning before we can approve it to make sure the height of the fence is okay
Okay.
and the location.
So from the city's perspective, there was fence, window, and door work that was done without a permit.
Yes.
Permits, there was a stop work order, the permit's now been applied for.
Yes.
And it's still in plan, it's still
It's
in
in
plan
zoning.
review.
Review.
Do you know how long it might take to get through zoning?
It could
to get
take a
the
week or
permit
two to
issued?
get through zoning.
And I think your earlier testimony is you were recommending 60 additional days for compliance?
Yeah, pretty much, because we still got to get an inspection or
Okay,
get it passed,
okay,
if it complies, but I can't make that decision.
understood.
But we're working toward it, so.
Okay, well,
I
let me
don't
hear
really-
from, are you Mr. Arias?
Arias, yes, sir.
Let me hear, go ahead and tell me your name and address, sir, and then let me hear from you.
Good morning, sir. My name is Michael Arias. I purchased this property May 20th of 2020. I don't know exactly what was done on the property prior to me purchasing it, but that's exactly how I purchased it.
Okay,
The fence was there. I believe the fence has been there for about 5 years minimum. I'd never put up a fence, so I don't have a permit for it. I never put up windows, so I don't have a permit for that either.
I'm having a little bit of a hard time understanding you, if you can.
I purchased this property 1 year ago.
Yeah.
Purchased the property 1 year ago. I never did any work to the property at all. Fence has been there for minimum at least 5 years.
Okay,
I don't want the fence there either. I do have violations for the fence since I am the owner now. I'm going to knock it down as soon as I get this, the new fence approved. And if you guys pull up the survey that was submitted, the new fence is farly offset away from the sidewalk, which is what they want.
okay.
So that's that's already in progress. I never changed windows or doors on the property. That's how I purchased the property.
So that's how you purchased the property?
Yes, and
Okay.
when I emailed Daniel Kempo, I asked him, what is this about? And he said, it's not about the windows and doors, it's just about the fence. I said, okay, that's already in progress. And about the 60-day, we do have a hurricane coming, possibly, we don't know. So that could delay when I put up that new fence and, knock down.
All right, let me stop you there. Let me get some clarification from the city. Are we talking about just the fence, or are we talking about fence, windows, and doors?
The only violation I've got is for the fence.
Okay,
He didn't write down what it, oh, wait, no, it's the fence, windows, and doors. If you look at the very top line of the violation, it says fence, windows, and doors.
And
so let me ask the city another question. According to Mr. Arias' testimony, this was all in play before he purchased the property. How did this, were these violations in place?
No.
So-
Still, the violations remain, and if the windows come out when the hurricane comes, who are they gonna come to but us?
I guess I'm very confused right now. According to the city's testimony, well, according to Mr. Arias' testimony, he bought the property a year ago. He has done nothing in terms of windows, doors, or fence work, and it was all already had occurred when he purchased the property.
Yes.
So I'm trying to understand when this code case started, how it started, and
It was found by the inspector, who wrote the violation on 10/5/20. What was the purchase date?
5. May.
so you bought
May
the property
20th.
in May?
Yes. And the violations were already in progress when,
Let me see the
For
there
purchasing
was
the property.
picture of like some busted out window frames and stuff. Can you go back to that?
Mr. Arias, did you say you purchased it in 2020 or 2021?
2020.
I can't hear you.
2020.
2020, okay, very good.
And that does not look like the,
So like, that was there when you bought the property?
no, that doesn't even look like my property.
That is what?
That does not look like my property.
That's
at all.
not your residence?
That's all. I'm not sure if they have the wrong file with the wrong pictures, but that does not look like it.
These are the photos that are attached to Malvern's case. So
Special magistrate, I don't think that we can move forward
We need
further
the
today.
inspector.
We're going to have to reschedule the case.
All
We need
right,
the inspector here.
I'm going to take this. My recommendation would be for the city to pull this case. I don't even want to continue it. My preference would be for you to pull it and figure out what's going on, and if you need to bring it back, then by all means, bring it back, but if,
Understood.
I'm, based on the testimony I've got, I'm not ready to find that there's any violation on
Understood.
this. So, that would be my recommendation on how to proceed on this one.
Understood, sir. Thank you.
So is that what we're doing?
Yes, sir.
All right, so the city is going to pull this case. I'm not taking any action on it. I'm not finding any violations. It seems like there's a lot of questions that need to be straightened out. So I'm not doing anything with this today. I'm not continuing it. I'm not making any findings that you're in violation of anything. I'm going to ask the city to stay in touch with you and ask you to stay in touch with the city and let these questions get answered. If there is in fact a code violation and it needs to be brought back, then the city can do that. And my hope is that this can all get worked out behind the scenes and you don't have to come back here at all. But, hopefully you guys can work that out.
Okay, I just have a question. So there's like it states $1,000 fee per day for the fence.
I'm not imposing any fines for code enforcement. I'm not sure what's going on with the building department. But I'm not imposing any daily fines at all.
Understood.
I'm not finding that you're in violation, and I'm not assessing any fines.
Understood.
Okay?
Okay.
All right, thank you.
Yes, sir.
Matter number 68, case number CE 2104-0566, case address 944 Ortega Road.
Did you say 60?
68.
68. Got it.
Give me one moment. Okay. Sony Bin, City of West Palm Beach, Code Enforcement. This property was cited on April 27th. Property was posted on April 28th, and certified mail was sent on the 28th. This property was cited for codes 18103B, 18106A, 18162A, 2232A, and 82144. I have not made contact with the property owner directly, but I spoke to someone a translator of the owner, and I also made contact with the tenant that's currently residing at the property, and she's also here. The property is still in violation for all code cases, 18103B, 18106A, 18622A, 2232A, 82144. The city is requesting an additional 60 days to gain compliance, or $100 per day until compliance is achieved. I spoke to the representative of the owner this morning, and they're in agreement with the city's recommendation as well. And I do have the tenant here that would like to say
I'm
something.
happy to hear from her if you'd like her to testify.
I'm sorry? I'm sorry?
I said I'm happy to hear from her if you'd like her to testify.
Yeah, just to mention, hi, my name is Tara Rosen, 944 Ortega Road. Good
Yes,
morning.
ma'am.
So basically, my friend and I and my daughter, we moved in, paid almost $10,000 to move in, and there was a lot of things that needed to be fixed, and kept getting the excuse that the husband was sick, so it was like 3 months. We kept trying to, get things fixed, and nothing was getting fixed, and, there was a lot of problems, obviously. And then finally, we saw a building inspection and saw even more problems. Tried to contact the owner, and it was kind of half-hearted attempts, and then finally, when they got cited, we've heard absolutely nothing from them.
Ma'am, how long have you been renting there?
Oh, good morning.
morning.
Mid-December.
I'm sorry,
Mid-December,
of 2020?
correct.
Thank you.
Uh-huh.
All right, thank you, ma'am. Anything else you'd like to tell me? All right, is there anything else from the city?
She can.
Shelley Kaufman, 944 Tager Drive,
Yes, ma'am.
and I'm the other tenant. So when we moved in there, the ovens don't work, the dryers don't work. My parents died, and I have antique furniture. We have it in the garage, full of termites, bugs, rodents. So there's a lot of unlivable conditions. So I just wanted to spell that out. We've really tried to work with them, and they just don't respond. There's no respect for tenant rights.
Okay.
Just wanted to say that.
I appreciate that, ma'am. Thank you. Yeah.
Thank you.
Just for the record, there's a termite inspection that's attached to the case. And also, there's an open building case that will be presented at the next hearing in July, I think July 21st.
Okay.
Just wanted to state that for the record.
All right. And then quick question, the violation of 82-144, would that be a one-time $250?
Yes.
Yeah. Okay. Okay, well, I do find proper notice in this case with the certified mail and the posting. Based on the evidence and the testimony that I've heard, I will find the property remains in violation as cited. I will accept the city's recommendation, allow 60 days for the property to be complied. Thereafter, daily fines of $100 per day will be assessed until compliance is achieved. Now, for the violation of City Code Section 82-144, that will be the assessment of a one-time $250 fine. Okay, thank you.
Matter number 34, case number CE 2104-0193, case address 255 Alpine Road.
Good morning, Officer Luster, West Palm Code. This property was cited for exterior paint condition, in poor condition, litter, trash, and debris, junk vehicles, inoperable vehicles, numbering standards, landscaping, landscaping of swell, lawn, landscape maintenance, and unpaved parking. Certified mail was signed on 4/2021. Property was posted on 6/17/2021. I have spoke with the owner of the property. She's here today. And speaking with the owner of the property, she informed me that she was trying to refi the property in order to get quite a bit of these things done, because the unpaved parking, she's gonna have to put in the driveway itself. And she needed to do a refi. I just found out this morning that it is also a lien from 2011 that's attached to the property for code violations, and she can't get the loan approved because of the 2011 lien. So we're gonna have to work that out. But that's my part of the story.
Okay. Let me hear from the respondent. Yes, ma'am.
Good morning. Yes, immediately upon...
And let me get your name, go ahead and put your name and
I
address on the record,
apologize.
and then you can proceed.
I apologize. Ruth Martinez Estes, 255 Alpine Road in West Palm Beach.
Thank you, ma'am. Go ahead.
Immediately upon getting notice of this, I immediately did an application for loan modification. I have proof of that if the court needs to see it. I immediately went and got bids for the driveway. I immediately got bids for the paint, so I have all those bids. So we were getting ready to finalize, and then the title company, and I have proof of that, indicating to me that the only thing holding up this refinancing so this all can be done was a 2011 lien that I didn't even know it existed. The lender, for some reason, the lien was said it was $200. They had indicated that they were going to absorb it or pay it out at the closing, because I guess the document said 200. It appears that that's not the case. So basically, right now, I talked to code enforcement about doing a reduction of the lien, but I cannot do that because this is open. So I'm kind of in a catch-22.
Textbook catch-22.
Yep.
They have advised me to go to the legal department and talk to them to see if what are my alternatives. But like I said, I instantly started working to bring everything in that up to date, but I am stuck because I cannot get the refinancing. I can tell the court that all this is going to cost well over $20,000. I have the bids. Like I said, I immediately went to get bids. I immediately went to the refinancing. I did everything, and the only thing that's preventing this is that 2011. It was a $200 lien, and the title company says they have reached out to the city of West Palm Beach to see about the payoff on how it's done. They have not heard back, so I am trying. Like I said, I have everything kind of in order in place, but this is the only thing that's holding me, and
Do we have any sense for the size of the 2011 lien? It's probably pretty big at this point, right?
We could look it up.
I guess it was, I don't want to,
I once made a phone call, and I
Look up
thought,
255 Alpine Road. and
well,
look up
regardless, I mean, I understand the
I
city's
didn't-
process. You can't ask for a lien reduction unless the property's in compliance. The
Right.
property's not in compliance, so you can't ask for the lien reduction, which means you can't get rid of the lien, which means you can't close the refi, which means you can't get the money to bring the
Right.
property into
So
compliance.
she is in a catch-22.
Yes, ma'am.
Special Magistrate, I apologize. Do I understand that the refi is to get money to redo the driveway itself?
That was
No,
the
to do the whole
testimony.
property,
Everything.
Everything that's on the violation.
Okay, I see.
That was the
So
testimony.
there has been what we call a conditional lien release.
That's really
Under
not
that
enough.
condition, that refi is purposely done for this violation to clear up the entire
It's-
11
It's
and
not an option on this case.
It's not?
And no, it's not. And the
Shouldn't have
property
given it.
owner and our office could talk offline about any potential options she has. Because I know we have a heavy agenda right here.
Excuse me? So what was the amount of that lien? That's the 2011? Okay, that was it.
What was it? I didn't hear.
35,000.
Okay. Is the city then asking to continue this, to try and work something, or have some offline discussions?
Well, I can have, our office can have offline discussions with her about lien reduction. But in terms of this particular case, I think that the city still needs to go forward and ask for a time certain with fines. And if fines develop on this case, those can also be brought to lien reduction with mitigating arguments by the respondent.
But
Ms. Martinez, let me ask you a question. Do you have any sense, you said you had gotten estimates or bids from contractors. Do you have any sense, or did they give you any indication of, once you signed a contract with them, what kind of time it would take them to get the work done?
some of them indicated, and I have all the copies here, that I would have had to sign the contracts within 30 days. I think the only thing that would take the longest time, obviously, would be the driveway, because that one does have to be permitted. The painting of the house clearly doesn't. The house, if you went by, the sod with the rain has been pretty much all green. The vehicle, I'm not sure why they are complaining about that vehicle but I can talk to the court enforcement about that. So the driveway is the biggest problem, and that's the one that's gonna need permitting, and that's the one that is the biggest ticket item. But I suspect that once I get the money, it's gonna be, to be safe, at least 2 months. I'm asking if we can abate this for maybe 4 months. Let me figure out if we can talk to the legal department, if I can come back. Like I said, I am without any delay, I started to try to work on this. But putting in the fines on something that I can't fix because I'm in a catch-22, it's $35,000. It's actually more than the repairs I'm borrowing for to fix.
Okay.
So it's not like,
Special Magistrate, very quickly, there is no opportunity for a conditional release on this, as this is not a new owner.
No, I'm
And
not inclined to.
So it's just a lien reduction, and I believe it takes up to 4 months, 120 days from the application to come in front of a magistrate.
Unrelated topic. Ms. Lester, what was the inoperative vehicle and,
At one point in time, it's constantly the Volvo. Is that a Volvo?
it's a Volvo.
It really never moves. Does it have a good tag?
It has a tag.
But is it a good tag?
Yes, it's always been registered.
Okay.
The other thing is, I don't understand,
Yes,
2
ma'am.
houses down from my house, there's an RV on blocks.
It's not
On
a
blocks that's been there for as long as I've lived there.
And it's screened off properly. I know exactly.
It's
what
not
you're
screened
speaking.
off at all. You were right in the front, it's there's nothing
You
blocking
can see it from the road, and that's within the code.
It's what?
You can see it from the road, and that's the code. You can't see it from each side. You see it from the road. That's perfectly fine.
You can't see mine from the side because of the hedge also. And you can see it from the road. It's exactly the same situation. Exactly. I have a hedge on that side that blocks it. They have a hedge on the side that blocks it.
Okay, we're talking about two different things, Ms. Martinez.
Like I said, I am glad to talk to the enforcement about that.
That's me.
If that's holding this up, I'm trying to sell the vehicle. It has to get sold.
Okay.
And I gladly, as soon as I can sell it, I will sell it. That's not the problem. It's not that I don't want to move it. It's not that I don't want to do anything that they are requesting of me.
Okay.
so your testimony is that it is a currently registered vehicle?
It's registered to my sister, yes.
All right.
It's not registered to me, it's registered to my sister. That vehicle is my husband's vehicle, he drives that.
And
The Toyota that was there is my son's, who's from home from college. The
Those
Jeep-
ones were also unpaved areas. The blue vehicle was sitting directly in front of the front porch, and it's not on pavement.
No, the
And-
parking I get. I'm
Okay.
just,
And
I was
the Volvo
questioning
that
the
we're speaking
inoperative
of
and
doesn't
the
have a good
abandoned
tag
were the ones the
But the
code
blue
sections I
vehicle
was.
comes in and out as my husband's vehicle, and the paved area is actually, that's where there was a
I
driveway.
understand, but the violation is the violation, Ms. Martinez,
But
and that's that.
I guess I don't know where they want me to park my vehicles. I mean, I guess I'll talk to her, but I'm just confused how they pick and choose who's being
Well,
violated.
we get
and
around
for
to
what.
all violations. It takes time to get around to all violations, so.
But the point of the matter is, I do want to fix it. The point of the matter is, I do want to get all this resolved. I am trying. I tried from jump. I'm having a catch-22 because of the lien from 2011. That's $35,000. I don't
No,
know.
I get all of that.
I just don't know what, I mean, I'd like some time I can call the legal department and see if I can come
I'm
to
gonna
a
gi- I'm gonna give you,
negotiation.
I'm gonna give you some time. I mean, the question that I'm still trying to figure out is the abandoned vehicle and the inoperative vehicle. I'm trying to see if that tire was flat. I mean,
It was at one time. It still probably is. The Volvo. The Volvo is the vehicle that I consider to be inoperable and/or junk because of the fact it did have flat tires. At one time, it was not even sitting.
well, in the
Quite.
picture, the Volvo looks like it has flat tire, and the tire in the back driver's side looks
Right.
flat to me.
So that makes it inoperable.
Yeah, so, okay. I get this case. So Is there anything else you'd like to tell me, ma'am? Again, I understand where we are. I understand the
If I can,
circumstances.
if the
I'm
car,
gonna-
if I can have a certain amount of time, I'm trying to sell it to get rid of it. And
wasn't
then
gonna
as
ask
to
for a
the
split
other,
order.
if I can have even more time for the other matter so I can reach the legal department to see if I can come to a negotiation or something and see what I can do.
Okay.
Okay.
Special Magistrate, I was not going to ask for a split order. I was going to have it all into one. And I was thinking of 6 months for her to come into full compliance or 6 months of $50 per day.
Okay. And I actually was at 5 months and $100 per day, so we're pretty
So we can
close.
switch it.
All right. There is proper notice in this case. Respondent is present. The city has proper notice documents in its file. Based on the testimony and the evidence that I have heard, I do find that the property remains in violation as cited. I am going to allow you 180 days, which is 6 months, to get this straightened out, get everything in compliance. In 6 months, on its face, sounds like a lot of time, but you've got a lot to do, so it's.
And speak with legal. Make sure we put that on the
A lot,
record. They
yeah,
should get
you
with the
need
legal
to, this
department.
needs, yeah, you can't put this off. This has to be done right away to get, to get all these issues resolved. And then I will, 180 days, and I'm gonna do $75 per day if compliance is not achieved within 180 days. And I will tell you what I tell other people, if you're getting close to the 180-day deadline and it looks like you need more time, you know, if there's a request for more time that comes back before me and I see there's been good faith effort and things have happened that were beyond your control, I will consider that seriously. But, you know, those are the things I look for, though, is were you really trying? Was the stuff happened that was outside of your control? Those are the kind of things I look at in granting more time. But, you know, that again is on you to keep track of that time. So that I will sign that order for 180 days and then $75 per day after that.
I'll be on this immediately. Thank you, Your Honor.
Thank you.
Thank you.
Thank you, I appreciate it.
Matter number 5, case number CE21060049, case address 550 Okeechobee Boulevard, UPH 18.
Morning, Michael Williams, Code Enforcement Officer, City of West Palm Beach. Property 550 Okeechobee, UPH 18. Special Magistrate, this property was initially before you on 6/2/21. You requested that the case be reset for the next agenda, which is actually today, 7/7/21. Also, in the interim, you requested that a reinspection be made in order to gain a status of the alleged violations.
Yeah, I remember that.
Okay. This particular case, CE21060049, was initially recited on 6/3/21. Certified mail was sent on 6/4/21. We do have a signed certified mail receipt on file. The property, as well as City Hall, was posted on 6/3/21. The property was cited for 18103I, equipment maintenance. We did conduct an inspection of the property. I met with the tenant and met with the owner of the property, Mrs. Salomon. Upon entry to the unit on 6/9, we were met with somewhat unsanitary conditions in the kitchen, as the top of the stove was soiled. There was some clothing articles and items that were kind of strewn around the unit. The tenant was asked if we could begin the inspection. Tenant did grant permission to do that. When I looked at the dishwasher, it was noted that the dishwasher was filled with dishes. So I don't know if it was working or, if it was just being used, for storage or whatever, or if those dishes were clean. The refrigerator was noted working. The tenant stated at that time that the ice maker was still inoperable. Also, with regard to the refrigerator, the light for the filter was noted eliminated on the refrigerator. The exhaust fan, which connects from the bedroom to the bathroom, was noted inoperable. Again, the stove was noted very soiled. The oven was literally being used as we were there to bake chicken. We noted that. The windows and sliders were not checked because it did appear that the tenant was becoming somewhat upset, and in an attempt to not belabor the point or cause the tenant to become even more upset or cause some negative impact there, we stopped the inspection at that point, and I advised the owner that we were going to leave. So that's what occurred on 6/9.
Okay. I mean, what are you recommending at this point, based on that inspection?
We probably want to hear what the owner has to provide in terms of facts with regard to the repairs, because she did provide an email detailing some dates that I guess contractors were supposed to go out to the unit and perform some services. Now, I don't know if those services have been performed or if they are still in process of being completed. That I do not know. The owner can shed more light on those things.
All right. I mean, I think I was pretty clear at the last hearing. I'm not finding a code violation because a filter in a refrigerator wasn't properly replaced. That to me
Right.
is absurd. That is not going to happen here.
Right.
It sounds like the testimony is that the oven is working. The photograph looks like the dishwasher is being used. So, let me hear from the respondent, and then we'll go from there. Go ahead and tell me your name and address, ma'am.
My name is Edma Solomon, and my address is 1001 Northeast 27 Terrace, Pompano Beach, Florida.
Yes, ma'am. Go ahead.
Okay. Mr. Williams, explained to you that after your recommendation you recommended last meeting that we have to do an inspection. I tried to contact the handyman that were recommended by the association to be available at the time of the inspection, so they would be witness that all the items that Ms. Bussing was claiming that we did not attend to when before the April 21st, complaint. But unfortunately, they stopped answering my messages, my emails, or my WhatsApp, because that's how I used to communicate with them. The last communication I heard from Mr. Stephen Caruso, he's the one that supervised the maintenance at the time. He said, at the time when I left, everything was fine, and I don't know what the tenant did to damage them. I have a copy of that, I can provide you with that message.
Why don't you show that to Mr. Williams, and then I'll take a look at that.
Sure. Okay, no, these are the things, I think it's in here. This is your notes?
Right.
You need them? You need a copy?
No, I actually have them.
You have a copy, okay. Okay, it should be here. Here. It's been a while since I've been there, and these devices were working properly, so I don't know if she damaged them. That's a message from the guy. His name is Stephen Caruso, and I have his name here as a... here, his name here as the handyman. This is the one. And he's the neighbor of Miss Busing. And I sent her an email asking her, please, can you contact him to please attend the inspection? She never replied to my email. Okay? Okay, so
So is there a document that I'm looking at or no?
No, I don't have that document. It's not a part of the actual file.
Can I give it to you? I have a copy for you.
What is, I thought you said you had email from the maintenance supervisor.
Not email. It's a WhatsApp, because that's how we were used to communicate with him, because we were overseas because of the pandemic, and he was the one taking care of all the maintenance at the apartment. So this one, was a message from him. It's on my phone, but I made a copy for it, a hard copy.
Yeah, I'm happy to look at that if you'd like me to.
Sure. Can I?
Did you see?
Yes, I've seen it.
Do you have any objection to this being made part of the
No,
record? Yeah, you can,
it appears to be a screenshot from someone's phone.
Okay.
It looks like a.
And why don't you hand it to Mr. Williams, and then he can bring it up.
Thank you.
That was first, like here, that was my question to him. When I sent him here, he's telling me what he replaced, what he did. And then he sent me, I said, but the tenant is saying that it's not fair. He said, it's been a while since I've been there, and these devices were working first, so I don't know if she damaged them.
Okay.
Here, this is my answer. I really don't know Steve, but the way she's presenting them, that they were never fixed.
Okay.
Okay?
All right, thanks.
Okay, then, so we after the meeting, I contacted Ms. Busing and all of them so we can set up a date, and Mr. Williams, according to his time. So we set up the date for the inspection on June 10th. And we went there. The handyman did not show up. So we were both of us. We were not welcomed at the apartment. The door was kind of like 2 inches open. So we stood there for over 10, 15 minutes waiting for somebody to come. But then she came very upset. And Mr. Williams started, because the kitchen is at the entrance. So we walked in the kitchen. The apartment is, I cannot consider it healthy, sanitary. I was so upset to see my apartment looks like this. The kitchen, very dirty, all the appliances, either misused or dirty or not taken care of or nothing. Mr. Williams explained to you what he saw in the kitchen, the fridge, the ice maker, all these. Then we walked to the bathroom to see the fan. It wasn't operable. Then we asked permission to go to the bedroom so we can check the window. She screamed from the living room, "Why are you here? I don't see any use for that inspection, da. So Mr. Williams said, "We're leaving. We're not gonna finish the inspection. We're leaving." And so we walked out, we closed the door, and we left. So after that, I said, okay, fine. Even though I sent an email to Mr. Williams saying, what shall I do right now? We don't know, we didn't check everything. So he recommended that I send contractors to do that job. So I contacted 3 companies, and I have here all the emails and so I contacted 3 companies to go there and inspect. So the first company was for the refrigerator, for the cooktop, for the dishwasher, and for the, okay, 1 second. Okay, so the first company, the first company was called Treasure Coast Mechanical. So he went there. I called him. He set up a date with Ms. Musing, and he went there. First, he checked the fridge. The temperature was perfect, and the food is there perfect. The freezer is perfect, 0 temperature. The filter he replaced. He replaced with a new one. And
I'm sorry, what, say that again?
The filter, the refrigerator filter, because she was complaining. So I said, we'll change it. It's okay. You know? So we changed the filter. And then the ice maker he saw that, in the bucket, and even Mr. Williams was witness, in the bucket there was like a big block of water, that ice, sitting there. So when he checked it, he told me that part for that ice maker was changed before, okay? When we did the maintenance before April 21st. So he checked it, and here it shows on his report. And he said that the part that was replaced before, it seems that it went bad again, which is like a board or something. So he replaced it, and it was under warranty. He didn't charge me for it because he said it was under warranty, because we changed it 2 months ago. And he says here something on his report that it could have been, like ruined. Either the door was left open of the ice maker, or it was misused. That's what made the board blew up again. So he changed it, but he didn't charge me, and here it shows on the receipt, okay? Then I called Casper Electric. They're a company to do so that's the dishwasher. The dishwasher, as I told you before, it was a brand new dishwasher, but it seems Ms. Boosing did not know how to operate it. So it was set on delay. So he fixed it for her, and he showed her how to operate it. The stove in working condition, we witnessed it because she was cooking chicken with the door open even, which I don't know how, but the door of the stove was open. And the cooktop, he checked it. She was complaining that it gives sometimes like misleading messages or beeps, that if like one is on, the other one will beep. He checked it, he called me, and he said, it's the sensor that's not working. That specific cooktop is manufactured by KitchenAid. So we contacted KitchenAid to see if we can buy the part, the top. But it's discontinued. That specific model is discontinued, so they don't have it. So now what we did is we said, okay, then we'll change not only the top, we'll change the whole cooktop. We'll put a new one. So he took the measurements. We ordered one from Lowe's. Also, I have all the documents here. Shows we received it from Lowe's. When we received it, the technician from Lowe's went to the apartment to take the cutout of the countertop, and he found out that the one we ordered is like short half an inch. So we needed to order another one. So we ordered another one, and we received it on Monday, which is the 5th. And the technician is ready to go install it. He called her on Monday, July 5th, and asked her if he can come today, Wednesday, to install the cooktop. She said she's not available. So he asked her for another date. She said to call her back. So she did not give him another date to install the cooktop. So this is done with the kitchen things. We go to the exhaust fan. The exhaust fan, we called Casper Electric. They gave us a date of June 30th to go there and fix it. The guy showed up, the technician. He checked it, and he found out, I have also the receipt here and his report, that because, as I mentioned before in the last hearing, that specific exhaust fan was replaced, and it cost us $325 to replace. But she denied it. But anyway, I have also the report saying the handyman that fixed it. Casper checked it. He sent on the report that it's a brand new exhaust fan. The only thing that was not good is like there is a connection, a power connection that's loose. He fixed it. He charged me only for service call. No parts, no nothing. Okay? So this is. Sorry,
So the exhaust fan's working.
I'm sorry?
The exhaust fan works.
It's working now.
Okay.
Yeah. Now we go to the windows and the sliding door. Also, we called Complete Sliding Doors and Windows. This is a company that's approved, and they do work at the building, at the building at the 550 Okeechobee Boulevard. So we called them, and they went on the 16th of June to check the window and the sliding door. Their report was the window is operable, but it's hard. Okay? And that's the reason why Ms. Boosing later, she accused me that I accessed the apartment without her knowing, and I lubricated the window, which is not true because I don't have a key of the apartment. She changed the key in March because she ruined the lock, and she called, we paid for a new lock, and I never got any key for the new lock. So that was something. So he said the window was operable, but it's hard. It's not easy. It's hard. And the sliding door is harder to open. You can open it, but it's harder. So he recommended to change the springs on the windows and the door. So since the window and the door for that building, the windows and the doors in that building are custom-made doors and windows, so they needed to order those parts, the springs that they need. And he told me at the time that it's going to take 3 to 4 weeks to order them because of the pandemic, and all the special order things are delayed. And since you can't find them in the market, these are things. So now, this is the only thing. We paid the deposit so they can order them, and we're waiting. I called them yesterday, Tuesday on the 6th, to just see where's the progress. They said it's going to take another 2 weeks because they put the order on the 18th. This is the one, and this is a copy of the deposit that I paid to order them. So this is here, and they placed the order on the 18th, and he said it's going to take 3 to 4 weeks to receive it. So it's not going to be before the 3rd week of July that we receive those springs, and then they can come and replace them.
Okay.
Okay. So that's all the maintenance. So everything is done except the sliding window and door that we're waiting for the parts. And one last thing I like to mention here, that Ms. Busing has been withholding rent for 3 months now. She was month of May, June, and now July too, saying to compensate for the repairs. And I don't know. We tried every effort since she moved. You see, when we first did the credit check on Ms. Busing, that was back in October. It came back that she owes a big amount of money to a rental community called. I have the name here.
I object to this. I represent the tenant. This has nothing to do with.
Your objection's overruled, sir. This case was brought before me. I'm going to hear from the respondent.
This testimony has nothing to do with the condition of the premises.
But,
This is getting to the.
It should be confidential.
Go ahead and wrap it up, ma'am.
Okay. And so anyway, so she owes for 3 months now, and it seems that it's a history because she owes for a rental community before. And it's called Avalon Studios. So anyway, she's refusing to pay, and her attorney is offering to pay only for the 3 months, $1,492 instead of $5,500. And we, as I said, we've been trying since last December to accommodate her with every, maintenance that she complained, but, and we got to this point now.
All right, thank you, ma'am. Mr. Williams, I have a question for you.
Yes, sir.
The violation regarding the windows, it indicates that the sliders are difficult to open. Are there other windows in that same room?
There's the 2 sliders which are in the living area, I believe, the living room area, and I think there's windows in the bedroom.
I guess the question is, the code requires certain things. Are those sliders required by code to be there?
I'm not sure. Well, you're saying are they required to be there, the sliders?
Let me get back to the code section that the city has cited is that every supplied facility which is required under this article, I'm going to guess an ice maker is not required by city code to be provided, for example. So my question is, are the sliders required under the article to be provided? Because if the code section that's cited is every supplied facility, equipment, or utility which is required under this article shall be constructed and installed that it will function safely and effectively and maintained in good condition. So my question is, are the sliders required by city code to be provided?
Well, Well, the unit was built with the sliders and the window, so I would assume that they
Well,
they
let me
would-
ask it a different way. Does the
Okay.
city require every refrigerator to have an ice maker?
No, it does
If
not.
the unit was provided with an ice maker and it doesn't work, is it the city's intent to cite that as a code enforcement violation? If the ice maker's not required and the ice maker's broken, is the city getting into the business of being a property manager?
Well,
and I'm sorry if I sound upset about this, but
No,
some of these
no, I get-
violations are ridiculous in my mind.
No, I get it. In my view, the reason I cited it was because it is supplied equipment. The sliders are supplied equipment. The windows are supplied equipment. And I did note that they were somewhat difficult to open.
So the question would be, are they required under the article? Because that's the code section that was cited. If, just because they're supplied doesn't mean they're required.
Right.
So that's what I'm struggling with right now.
Okay, that I understand. But from my standpoint, I cited them because of the fact that they are required and that they are supplied rather. It's supplied equipment that is somewhat difficult to operate.
Okay. Do you have any other witnesses that you wanted to have testify?
Okay.
Go ahead.
Good morning, Special Magistrate. My name is Joshua Payne. I represent the tenant, Ms. Victoria Busing.
Yes, sir.
We've both been sworn in. Judge, I've heard an amazing story today, little of which actually deals with the conditions at the property. It has not been re-inspected since June of the 9th, and what we have is some evidence here of some things being fixed. But we're all here not knowing because the code inspector hasn't looked at any of these things and said for himself.
Well, with all due respect, the testimony from Mr. Williams was that your client was difficult and did not cooperate with that inspection.
Sure.
So I put that on you.
Let me explain that, Judge. This has been pending since April the 14th. That was with the original code violation. In that report, there was nothing that related to any conditions of the property that were unsanitary or otherwise embarrassing. That has been there since April 14. It originally came up on your June 2nd docket. At that docket, the owner who had said, well, I don't know what exactly needs to be fixed. So it was agreed and ordered by you that she appear with her handyman so Mr. Williams could specifically point out what it was that needed fixed, because she said she didn't know what it was. Well, June 9th is the day that they came for the inspection, and she didn't bring any handyman with her. She had never had anyone come and do any work on the apartment, so it was exactly the same circumstances as it was in April. And that's why my client was upset, because it was all a waste of time. She was ordered to have a handyman there. She actually only talked to the handyman the day before and asked them to show up. And one other handyman stopped returning her calls. So this was a ridiculous waste of time in which the only real purpose was for her to show up and give my client a 3-day notice that she had sent earlier that she took out of her U.S. mailbox. And what's interesting about this, Judge, is although she professes that she did not know what needed to be fixed, she didn't have a handyman there, and then actually after that date, after the June 9th date, is when all the work starts to be done without having any handyman there to be told by Mr. Williams what needs done. And so those things have been, a lot of those things have been accomplished, to my understanding. I'm not a code person, but a lot of those things have been accomplished only since that point, without a handyman needing to be told from the code people what needs to be fixed. Now, the biggest thing that remains, and I think what you're hitting on, Special Magistrate, is that the doors and windows, I understand, are life safety issues for egress purposes. These need to be fixed. She has in fact shown us an estimate where she's put a whole $100 down on a estimated $2,100 repair. Now, her lease runs out at the end of November. We're concerned that she's just going to run out the clock and then not have to do these repairs. We think that, Judge, there needs to be an incentive to finish this. A lot of these things were were simple and small repairs, and my client has been cooperating. If anyone wants to come in at any time, if Mr. Williams wants to come back and look, that's fine, you can inspect, but obviously at the June 9th reinspection, there was no reason to. She didn't bring the handyman she was supposed to, and no one had been there since April the 14th. So Judge, I believe what needs to be done is have some set date that this gets done, because I can see what's happening. She's building a case already that these parts are special, super special parts that no one's ever seen before, and they're coming from some exotic location, and they will be pushed back yet again. So I'd like some, my client would like some impetus, some incentive for the landlord to complete repairs.
Somebody verify for me, there's the picture. UPH18, is that stand for upper penthouse on the 18th floor?
Yes.
Okay, so what I would like is some testimony from somebody who's qualified to give it as to the life safety quality of an 18th story sliding glass door and in terms of egress. I need to be educated on, and I'm not trying to be facetious, I'm trying to understand the life safety side of an 18th floor sliding glass door. Why
there's a fire
that's a life safety issue. It's not as though you can go out that
Your
door and get to safety, to my knowledge. So,
Your Honor, if there's...
just a minute,
oh,
are you, what I would like is somebody from the building department or somebody who's qualified to testify about life safety and sliding glass doors on the 18th floor and how, and explain that to me. Again, I'm not trying to make it sound like I'm being a wise guy. I don't understand.
Okay, Your Honor.
I would like to be made to understand. Yes, ma'am.
Me?
Or who?
Oh,
I'm
oh,
sorry,
okay.
I thought it was the city attorney
Oh,
speaking.
no, it was me, sorry.
Go ahead.
No, if there is in light of a fire in the hall, and if I were stuck in the unit, I would not be able to leave the unit because the sliders get stuck and they don't open. Sometimes they open, sometimes they don't. And the windows are so difficult, so if a fireman had to come in to the 22nd floor to try to release me out of the only exit would be the windows and the sliders, and they don't function. And also, it doesn't, aside from that, I have to run my AC all day because there's no airflow into the room where the windows are.
Okay, so now we're talking about a whole nother issue.
Yeah,
This case, let me tell you something, this case has bothered me from the first time I heard it. To me, this case sounds like the city is being asked to be a property manager and not a code enforcement entity, because we're talking about an ice maker that doesn't work and refrigerator filters that haven't been installed and the dishwasher that's not running correctly. Those were the things that were complained about to me at the first hearing. And quite frankly, I think that it's not my place to say, but none of that sounds like it complies or applies to the code section that's been cited.
Magistrate,
I'm a little bit concerned about the windows and doors, but again, I'd really like some testimony from someone who's trained in that discipline to tell me about that. Yes,
May
sir.
I be heard? As far as the life safety, Mitch Postman, Code Enforcement. As far as the life safety issue is concerned, we are trying to see if we can get someone over from building that would be more of an authority on, since this is building code. However, the code relevant to this case is not just about required equipment, it's also about equipment supplied has to be in working order. The city definitely agrees we don't want to be property managers. We are unfortunately often put between tenants and landlords for their disputes. All we can work with is what the code specifies, which is that supplied equipment does have to be in working order.
And the testimony that I've heard today is that the refrigerator and freezer work, that the exhaust fan now works, that the oven works, that the dishwasher works.
I'm not disputing the testimony. I'm just, I guess, answering an early question about the ice machine and the relevance.
And I thank you, Mr. Posner. I appreciate that. So, I mean, quite frankly, at this point, based on what I've heard at this point, I am not willing to find any violations regarding any of those appliances. I'm still concerned about the windows and sliders. That is really the one thing that does give me cause for concern.
Your Honor.
Now, it sounds like there was testimony from the respondent that you reached out to someone to repair those.
Contracted with them, we signed with them. And they ordered, they placed the order. And I have, I don't know, like, I don't know, but I know this is not your job to call them, but we can call them and, like, to confirm. I don't know what else to do. I called a couple of companies, all of them, they're, like, they need time to order the parts.
Have you signed an agreement with them to get the work done?
Yeah,
Were they able to tell you how much time they thought it was going to take to complete the work?
They did put it. They put it in writing for me, that it's going to take 3 to 4 weeks to receive the parts, and as soon as they receive them, they will call to replace. But they said the window is operable in the room. It's hard, but it's operable, and that's why Ms.
But city code requires that it be function safely and effectively and maintained in good working condition. So difficult to open, in my view, doesn't get it. It has to be in a condition that functions safely and effectively, and it has to be maintained in good working condition.
that's
So,
what
I mean,
we're
based on
trying
what
to-
I've heard, that is not the condition of the sliders or the windows.
And that's what we're trying to do by contracting with this company. And this company is approved by the building, by the association. They did so many apartments in the building. So they are, they're well known to the association, and they recommended them to me because they have, those windows and doors are special, custom made for the building because, so I don't know why. Then that's why their parts also are special parts, and those, they ordered them.
Okay, let me come back. Do you have anything in response to my outburst as well as the testimony from the respondent?
Yes, I did want to say, I did receive a call a couple of days, or maybe it was yesterday. I told you when I received about the stovetop, the malfunctioning, which is a real hazard. And he did say, was I available this morning? But I told him I was coming to court, so I wouldn't be available, but I said tomorrow morning. So he's supposed to be calling me tomorrow morning to schedule that. Your Honor, I'm very cooperative. I've been fighting and advocating for these changes since December.
Okay.
One more thing. Can I say something? Because she's claiming that since December she's been doing this and we did not take care. Is there a way that I can do an affidavit for the handyman so they can come in front of you?
Well,
They keep saying that,
I'm not continuing this again. I'm entering an order today, so I'm not, if the evidence is not here today, I'm not going to consider it. Mr. Posner, I guess based on what I've heard, I have an understanding or an idea. I think that the windows are a violation. I'm prepared to make that finding without more testimony. So if you called someone in, I don't want to belabor this or drag somebody away from their desk unnecessarily.
We sent an email and sent someone across to look for somebody from building. I don't know how successful they
I
are.
think based on what I've heard, I've got enough evidence for this hearing to make
Understood.
that finding. I don't think it's necessary.
Yes, it's been beleaguered long enough. I agree, sir.
Okay. Here's what I'm doing in this case. I first of all find proper notice. The respondent is present. The city has the proper notice documents in its file. Based on everything I've heard, I am going to find the property to be in violation of City Code Section 18103I in two respects: regarding the stovetop, because I think that needs to be fixed, and regarding the difficult to open sliders and windows. I'm not going to find violations for any of the other appliance issues that were brought to my attention. From what I've heard, the stovetop's getting fixed this week, hopefully tomorrow.
I hope so.
Sounds like you need about 30 days to get the windows and doors fixed. I'm going to give you 45 days to comply with
Definitely will
the
be done.
sliders and windows. After that, though, there will be daily fines of $150 a day after that 45 days.
They will be done, definitely.
Now, I'm directing, to the extent I can do this, I'm directing you guys to cooperate with each other on this. There needs to be, you need to bring the appropriate handyman, you need to be available and make the unit available to the workers. I need you guys to work together. No offense, but I don't want to see any of you again, not on this. So I think that is a fair resolution. I think it's the appropriate resolution, and that is the order that I will sign in this case. Thank you
Can I ask
to
you one
everybody for
question?
coming.
Can I ask one question?
Yes, ma'am.
I don't know, probably it's not here, but can she withhold rent and not pay rent?
That is so far above my pay grade
Okay.
that,
Okay. Do you need any of the copies of the contracts or with the company or no?
I don't need to now.
Okay, okay, thank you.
Okay.
Thank you for your time.
Thank you, everybody.
Thank you, Your Honor.
Okay, okay, thank you.
Just confirming we have no respondents present. Okay.
We got a little bit of time before the 11:30s. Let's see how many of these we can get through before.
Okay.
And then.
Okay. Going to matter number 4, case number CE 21050242, case address 920 South Mangonia Circle.
Yes, John Frosco, West Palm Beach Code. Property was declared a chronic nuisance on May 18th of 2021, and notice of violation was sent and posted certified mail. I got no response from the owner of the property, no action plan, nothing. Notice of hearing of hearing was sent out on June 8th of 2021, and the property was posted. Still no response from the owners of the property. No action plan submitted. The city is asking formally to declare this a chronic nuisance and enter a service order with all costs billed back to the owner, including officer's time.
Has the city done any abatement work on this lot
Yes,
in the
twice,
past?
in
Let's say
two
must-
prior adjudicated cases.
That's what I figured. Okay. Do we have here anybody? There's nobody here on behalf of the respondent. You did posting, and there's a photograph of the posting. And did you have returned certified mail in this for today?
The mail was returned certified, and that is a valid address. I think the children live at that address.
Okay.
We also have another property on 22nd Street that's already been declared a chronic nuisance.
I see. Is that a vacant lot as well?
No, it's a house.
That's the occupied one?
No,
Okay.
it's unoccupied.
Just a structure
vacant
that's
structure.
unoccupied. Gotcha. All right, well, in this case, I do find proper notice, even though the respondent is not present. Based on the testimony and the evidence, I do uphold the city's declaration of chronic nuisance, authorize the city to provide chronic nuisance services, bill those costs to the owner of the property. I think that covers it. I think that everything I need to say on that.
That with all costs billed back to the owner.
Yeah, I said but you assess all the costs back to the property owner.
Yes, sir.
Thank you.
Thank you.
Matter number 6, case number CE 21050089, case address 6121 Wildcat Run.
And what was the agenda item again?
Number 6.
Number 6, for the very next one. Okay. Thank you.
And you have that order as well.
Good morning. Joseph Oliva, Code Enforcement Officer for the City of West Palm Beach. This property was declared a chronic nuisance on 5/7/21. The declaration was posted on 5/7/21 and certified mail sent on 5/10/21. There has been contact with the owner, but no action plan to date. The notice of violation was posted on 6/16/2021 and certified mail was sent on 6/16/2021. The property's been owned since August of 2001. Its previous adjudications was CE 200600097, and that was on 7/16/2020 for remove prohibited trees and failure to comply. The city requests that the special magistrate find a pattern of nuisance activity and enter a chronic nuisance service order for services to be provided by the city to include, but not limited to, landscape maintenance, removal of any trash and debris, trimming of any trees or hedges with access to the property, and any other abatement methods necessary to keep this property in compliance.
Have you done previous abatement on this lot?
Yes, sir. It was back in 7/16/2020. It was they had cleared the property. It was abated by the city.
All right, well, I do find proper notice with the posting and the certified mail, even though the respondent is not present. Based on the testimony and the evidence, I do uphold the city's declaration of chronic nuisance. I authorize the city to enter the property, abate the chronic nuisance violations, and provide the appropriate services to the property to keep it from being a nuisance, and assess those costs against the property owner.
Thank you.
Thank you.
Matter number 7, case number CE21050098, case address 3703 North Flagler Drive.
Good morning, Christopher Thompson, City of West Palm Code Compliance. Property at 3703 North Flagler was cited on 5/10/21. Notice of violation in City Hall was posted also on 5/10/21. Property was cited for a prohibited trailer, and no BTR, rental license, or COU. As of yesterday, the trailer was removed, but the owner still does not apply. He still doesn't have the BTR yet. I have spoken to him. He's in the process of getting the BTR, so I'm requesting an additional 30 days to come to compliance, or $150 a day until compliance is achieved.
Is the 82-144 the one-time assessment of $250? Is that? And the trailer is?
The trailer is gone.
That's complied?
Yes.
Okay. So that's 94-487B1. But everything else still outstanding?
Correct.
Okay.
Chris, in your contact with the owner, did he deny that he's renting?
No.
Okay. All right, well, the city has proper notice with the posting in the certified mail, even though the respondent is not present. Based on the testimony and the evidence that I've reviewed, I find property remains in violation as cited, except that property has complied with 94-487B1. For the other outstanding violations, I'll allow 30 days to comply. Thereafter, daily fines of $150 per day until compliance is achieved. Except for 82-144, that code section, I will, the violation, I will assess a one-time fine of $250.
Thank you.
Thank you.
Matter number 8, case number CE21050331, case address 525 35th Street.
Good morning, Joe Petrick, West Palm Beach Code Enforcement. This case is in reference to a single-family residence that was issued a notice of violation via certified mail and posting on May 26th for trash and debris to the rear of the residence along the alley. No address characters posted in the alley. A fence in disrepair and landscaping violation of city code. Notice of violation gave 10 days to remove the trash and debris and post address characters, and 30 days to restore the landscaping per city ordinance specifications and to repair, replace, or remove the fence. After the notice of violation was issued, I spoke to the respondent over the phone on a few occasions, and we also had some email correspondence back and forth as well. As of today, the property remains out of compliance with all code sections cited. 18106A, trash and debris remains in the alley. 78-6, no address characters have been posted. 94302A4, the fence remains in disrepair and no permit has been applied for to replace the fence. 94446-2, the front lawn and swale has been restored to city code specifications, but the vegetation to the rear along the alleyway still needs to be addressed.
So the code section is still in violation, even though they've fixed some of it?
Yes, sir. Yes, sir, that's correct.
Okay.
The city is asking for compliance within 30 days or a $100 a day fine be assessed.
All right. I find proper notice with the certified mail and the posting, even though the respondent is not present. Based on the testimony and the evidence I've reviewed, I find the property remains in violation as cited. I'll accept the city's recommendation, allow 30 additional days to comply, and daily fines of $100 per day after that until compliance is achieved.
Thank you.
Matter number 9, case number CE21050359, case address 523 28th Street.
Joe Petrick, West Palm Beach Code Enforcement. This case is in reference to a rental Airbnb property operating without a rental license or certificate of use. A notice of violation was issued via certified mail and posting on May 26th and gave the respondent 30 days to comply by obtaining a rental license and certificate of use. Prior to issuing a notice of violation, I spoke to the respondent regarding the same, and he advised he would obtain a rental license and a COU. As of today, the property remains out of compliance with City Ordinance 18162A for the rental license and 2232A for the COU. It does appear that the rental license was applied for, but there's back fees from 2018 that haven't been paid yet, including for this year, and that's why it hasn't been obtained, okay? The city is asking for compliance within 30 days or $100 a day fine be assessed.
All right, thank you. I do find proper notice with the certified mail and the posting, even though the respondent is not present at today's hearing. Based on the evidence and the testimony, I will find the property remains in violation as cited. I'll accept the city's recommendation, require compliance within 30 days. Thereafter, daily fines of $100 per day are assessed until compliance is achieved.
Thank you.
Matter number 10, case number CE 21040401, case address 625 Avon Road.
Don Williams, Code Enforcement. 625 Avon Road was cited for 18406L, which is landscape requirements, 94442E, which is landscaping the swell area, and 9471C, outdoor storage. And I cited this property on 4/20 of 21. Certified mail was actually sent 5/28 of 21, and I posted the property 6/4 of 21. Contact has been made with the owners of the property, and we agree they need an additional 30 days to comply this, or a $100 fine after that.
And you said they had no objection to that when you spoke to them?
No, none
I
at
just
all.
want to make sure I heard you right. All right. All right, well, with the certified mail, the city has proper notice, even though the respondent is not present. Based on the evidence and the testimony I've reviewed, I find the property remains in violation as cited. I will accept the city's recommendation, require compliance within 30 days. After that, daily fines of $100 per day will be assessed until compliance is achieved.
Matter number 11, case number CE 21040522, case address 420 Westwood Road.
Don Williams, Code Enforcement. 420 Westwood Road was cited for 18106A, clean and unsanitary condition, 18106B, excessive growth, 18106K, landscape maintenance, 18106L, landscape requirements, 7434A1J, which is trash cans placement, and 74-4-C-4, which is obstruction of right-of-way, and 94442E, landscaping of swells and the parkways. I actually cited this property on 4/24 of 21, and certified mail sent out 5/26 of 21, and posted the property on 6/25 of 21. Contact has been made with the owner of the property. He has made some progress, but not actually complied everything as of yet. So I'm asking 30 days to comply all violations, or $100 a day after that.
I'm sorry, you broke up in my ears. So what's your recommendation?
30 days, $100.
30 and 100? All right. All right, the city does have proper notice with the posting in the certified mail. Based on the evidence and the testimony I've reviewed, I find the property remains in violation as cited. I will accept the recommendation, require compliance within 30 days. Thereafter, daily fines of $100 per day will be assessed until compliance is achieved.
Matter number 12, case number CE 21040523, case address 415 Upland Road.
Don Williams, Code Enforcement, cited this property 415 Upland Road for 18106K, landscape maintenance, 18106L, landscape requirements, 18106B, excessive growth, 2223A, certificate of use, 74341-J, trash cans placement, and 94442E, which is landscape in the swell area. I actually cited this property on 4/24 of 21, certified mail mailed out 5/26 of 21, and posted the property 6/25 of 21. Contact, it has been made with the owners. They're out of town, they're not local. They have made some improvements, but again, they're not finished. So I'm allowing them additional 30 days or $100 a day after that.
You said they've done some work, but everything is still outstanding at this point.
Correct.
Okay. All right, with the posting in the certified mail, the city has proper notice, even though the respondent is not present. Based on the evidence and the testimony I've reviewed, I do find the property remains in violation as cited. I will require compliance within 30 days. After that, daily fines of $100 per day will be assessed until compliance is achieved.
Matter number 13, case number CE 21040557, case address 711 Belvedere Road.
Don Williams, Code Enforcement, 711 Belvedere Road, cited for 18106B, which is repair roof, walls, and foundation. 18106B, excessive growth. 74-4-C-5, cleaning of right-of-way. 78-6, number standards. 94402B-2-2, which is banners, balloons prohibited. And 94485E, resurfacing of the parking lot, and 9471C, outdoor storage. I actually cited this property on 4/27/21, certified mail sent 5/26/21. Property was posted 5/26/21. Contact has been made with the owner of the business. He need additional 90 days to complete the parking lot portion of that. $100 a day fine after that.
I just want to make sure, when you were going through the list of violations, I didn't hear you say 34102A. Is that still one of the
34102?
the junk abandoned vehicle?
No, I ain't no, not 34102A.
That is not?
No, that's not one of the violations.
Okay. It's on my agenda. So.
And 711 Belvedere? It's not on mine. Let's look at that one. 18106B, 18106-3B, 74SC. I don't see that one on mine. I don't see 34102A. Okay. There were a junk vehicle in the rear, but I don't have it on. That's my violation for some reason. But that is complied.
That's complied? Okay.
74 Belvedere?
Oh, you are, I'm sorry, it's just a different printing.
But that is compliant. That vehicle has been moved.
Okay.
But I don't
so-
see it on my violation list, but it has been removed.
And all the others are still outstanding, though?
Yeah, it's been removed.
Everything else remains outstanding?
Yes, I need an
Okay.
additional 90 days to comply, everything else.
And what was the daily fine you're recommending?
$100 after that.
All right. Okay, we do have proper notice in this case. Based on the testimony and the evidence, I find the property remains in violation. As cited, 34102A, though, has complied. I will require compliance with the outstanding violations within 90 days. Thereafter, daily fines of $100 per day will be assessed until compliance is achieved.
Thank you.
Matter number 14, case number CE 21040540, case address 5109 Pinewood Avenue.
City of West Palm Beach Code Compliance, Robert Watkins. This property was cited on April 26th. Certified mail was sent April 27th. Certified mail was received April 30th. This property was cited for 94-302A-4, 94-442C-1, 18-106M, 18-106G. Compliant violations are 94-302A-4. Remaining violations are 94-442C-1, 18-106M, and 18-106G. The city is requesting an additional 30 days or $50 per day after.
Okay. Okay, with the received certified mail, the city has proper notice. Based on the evidence and the testimony, I will find the property remains in violation as cited, except it has complied with 94-302A4. I'll require compliance with the outstanding violations no later than 30 days. After that, daily fines of $50 per day will be assessed until compliance is achieved.
Matter number 15, case number CE 21050132, case address 608 59th Street.
City of West Palm Beach Code Compliance, Robert Watkins. This property was cited on May the 11th. Certified mail was sent May the 12th. Certified mail was received May the 14th. This property was cited for 54-262, 18-106-A, 18-106B, 94-71C. No violations have come into compliance. All remain outstanding. The city is requesting 20 days or $100 per day after.
That's what I was looking for. All right, with the received certified mail, the city has proper notice, even though the respondent is not present. I will find the property remains in violation as cited based on the testimony and the evidence that I've reviewed. I'll accept the city's recommendation, require compliance within 20 days. After that, daily fines of $100 per day will be assessed until compliance is achieved.
Matter number 16, case number CE 21050405, case address 434 58th Street.
City of West Palm Beach Code Compliance, Robert Watkins. This property was cited on May the 27th. Certified mail was sent May 28th. Property City Hall was posted June 17th. This property was cited for 94-302A-4, 74-34A-1J, 94-71C, 26-35-B, and 74-4B-1. Compliant violations are none. All still remain outstanding. The city is requesting 25 days or $100 per day after. And for the repeat violation, $150 fine.
Okay. Which violation, which code section is the repeat and what was the prior case?
The repeat is for 74-34A-1J. It's the garbage can placement and outdoor storage.
Garbage can placement and outdoor storage?
Yes, sir.
Okay. So that's 9471C and 7434A1J. For the record, what was the prior case that found those violations?
It was, I've written down too. Oh. No, it was the, go up, the second one down, CE is 078, yeah, that one. Yep. Yeah, it's CE 19020078. Say again?
And can I see the order finding violation on that 2019 case?
There it is, right there, yeah.
And we're talking about 74. I see 9471C. I don't see 7434A1J. I thought it was a 2019 case. This looks like a 2020
No,
case.
it was this, it wasn't 2019. Yeah, actually, it is the 94-71C.
Okay.
It was the
And then I thought I saw an affidavit of compliance. Can you show me that again real quick? Yeah. Okay, so that complied in July of 2020. And when was this repeat violation first observed?
June the 3rd.
June 3rd. And did it come into compliance? Still outstanding?
No, it came into compliance.
What day did it comply?
It came into compliance on the 6th.
June 6th?
Mhm.
So it was in violation for 3 days?
Yes, sir.
And you're asking for $150 per day for each of those 3 days?
For the 3 days total, $150.
For the repeat case?
Yes, sir.
Yeah. Okay. I don't remember if I made a finding of proper notice or not. I do find proper notice with the posting and the returned certified mail. Based on the testimony and the evidence, I do find the property remains in violation as cited. I find that the violation of 9471C is a repeat violation based on the 2020 case. And that in this current case, that violation remained in place for 3 days. I will assess daily fines of $150 for the 3 days, June 3rd. I guess it's 4 days, 3rd, 4th, 5th, and 6th. Or is it 3 days?
Yeah, it came in the
Came into
night prior, she
compliance on
sent me
the
the
6th.
pictures, but then when I went out, it was the next day, so my pictures will reflect the next day after, so it was only 3 days total.
Okay, so $150 a day for 3 days, from June 3rd, when it was first observed, through the 4th and the 5th. For the remaining cases, or the remaining code sections, what do you want, what's your recommendation for?
Took $25 to come into compliance in 20 days.
I'll accept that recommendation. I'll require compliance within 20 days for, and that's going to be 74-4B1, 94-302A4, and 74-34A1J, or $50 per day for every day after that. Okay, did you get that?
Just to clarify on the repeat violation, is it a one-time fine of $150 or are
No,
we doing?
it was in violation, it was in repeat violation for 3 days, so it's $150 per day for each of those 3 days.
Okay, so for a total of $450 then?
Yes.
Okay, thank you.
Yeah.
Matter number 17, case number CE21050429, case address 710 55th Street.
City of West Mutual Code Compliance, Robert Watkins. This property was cited on May 28th. Certified mail was sent May 28th. Certified mail was received June the 1st. This property was cited for 94-302A-3. Remaining violation are 94-302A-3. I just noticed this morning that they applied for the permit for the fence. The city's requesting 25 days or $50 per day after.
Okay. So they applied for the permit this morning?
This morning, yeah, it popped up applied this
Okay.
morning.
All right, well, with the received certified mail, the city has proper notice, even though the respondent is not present. Based on the testimony and the evidence, I do find property remains in violation as cited. I will allow 25 additional days for the compliance to be achieved. After that, daily fines of $50 per day.
Matter number 18, case number CE21040650, case address 244 Bunker Ranch Road has complied. Matter number 19, case number CE21040669, case address 236 Murray Road.
Richard Pasmino, City of West Palm Beach Code Enforcement. This property was cited April 30th, 2021. Certified mail was sent out May 3rd. It was returned. In addition, the city and City Hall and property were posted on May 3rd, 2021. This property was cited for Florida Building Code 105.1, failure to secure building permit for the driveway. 94-451A, location of artificial turf. 94-451D, artificial turf. And Florida Building Code 110.3, required inspections. The property was remodeled, but the driveway wasn't part of the permit on any of the approval. And at some point, it has strips of artificial turf. I made contact with the contractor who did the remodel, Tyler with Paul Construction. After research, we both determined that the driveway was not included in the remodel permit. Separate permit is required, and they do intend on getting the permit and meeting the requirements so that artificial turf would have to be removed. The city's recommending 6 months to get required permit inspections and meet the artificial turf requirements in the code section cited. If not, the city's asking for $250 a day fine until compliance is achieved.
All right, with the posting and the return to certified mail, the city has proper notice, even though the respondent is not present. Based on the testimony and the evidence, I do find the property remains in violation as cited. I'm going to hate myself in August, but I think for consistency's sake, I'm going to continue the remainder of this hearing to the August 4th agenda, pending the August 2nd City Commission workshop on artificial turf, and we'll see what happens.
Would that be split order, though, for those artificial turf
Pardon?
code sections?
I'm finding them in violation
Okay.
of everything. I'm not imposing a deadline to comply, and I'm gonna
Okay,
wait.
because the driveway is a separate issue.
I understand, but I think I'm just going to.
Okay.
We'll continue the rest of this hearing until August 4th.
Special magistrate, the city would just place the
Understood.
objection for the record.
City can have a standing objection on any more of these and this one
Thank you.
on that decision.
Matter number 20, case number CE21050141, case address 4801 George Avenue.
Richard Pasmino, City of West Palm Beach Code Enforcement. This property was cited May 12th, 2021. Certified mail was sent May 13th and signed for May 17th. This property was cited for 34102A junk abandoned vehicles, 18106A clean and sanitary conditions, 9471C outdoor storage. This is those are not the photos. That's not the case. 4801 Georgia. The property is commercial. There's a taxi business there that has some broken down taxi vehicles there and outdoor storage and trash. I've had no recent contact. Originally, when citing the property, I did speak to the taxi business and informed them about the violations. But as of yesterday, the violations still remain. The city is recommending 14 additional days to comply with these code violations, or a fine of $50 a day until compliance is achieved. One of the vehicles is removed, the one that was on the street, but the one on the property still remains.
Is that so that presumably a vehicle covered by that blue tarp is one of the things we're talking about?
That one was removed.
That one was removed.
And that was on the street. But this one's still there.
Okay. Okay. All right, well, you have signed certified mail, so the city has proper notice, even though the respondent is not present. Based on the testimony and the evidence, I do find property remains in violation as cited. I'll allow 14 additional days to comply. They just have one vehicle to remove at this point?
Yeah, there's still one on the property, expired tag and flat tire.
Okay. I know you recommended $50 a day, but I'm going to do $100 per day. This is a commercial property, and this should not be a difficult thing to comply with. So,
okay,
$100 per day on that.
Thank you.
Matter number 21, CE21050312, case address 5518 Park Circle West has complied. Matter number 22, case number CE21060133, case address 336 South Chillingworth Drive.
Officer Williams, City of West Palm Beach Code Enforcement. This property was originally cited June 9th, 2021. Certified mail was sent June 10th, 2021. That was returned June 20th, 2021. The property, as well as City Hall, was posted on June 17th, 2021. To date, I've had no contact with the owner, just the surrounding neighbors of the property. They were originally cited for 74-34-A1J and 94-487B-1. As of this morning, all violations are currently still on the property. The city is requesting 15 days to bring this property into compliance, or a $100 a day fine thereafter.
I missed the garbage can placement. Where's?
It's on the side of the home there.
I saw the shopping cart. I didn't see the garbage can. Oh, I see. Okay. All right, with the returned certified mail followed by posting, the city has proper notice. Based on the testimony and the evidence, I do find the property remains in violation as cited. I'll require compliance within 15 days. After that, daily fines of $100 per day until compliance is achieved.
Matter number 23, case number CE 21060144, case address 1506 39th Street has complied. Matter number 24, case number CE 21060146, case address 1600 39th Street.
Officer Williams, City of West Palm Beach Code Enforcement. This property was originally cited on June 9th, 2021. A certified mail was sent June 10th, 2021. That was returned June 16th, 2021. The property, as well as City Hall, was posted on June 17th, 2021. To date, I've also had no contact with the owner. As of this morning, the property is still out of compliance. They were originally cited for 18-106B, the overgrowth there. It's just an open lot with overgrowth. City is requesting 5 days to bring that into compliance or a $100 a day fine thereafter.
All right, you're not seeking abatement at this point?
Yep, you know what, I am seeking
lot,
abatement. I forgot to write it down.
This is a vacant lot?
Yes, sir.
All right, and you are asking for abatement?
Yes, sir.
Okay. Yeah, the height of that vegetation, in my view, is a health, safety, welfare concern. I do find proper notice with the posting and the return certified mail. Based on the evidence, I find the property remains in violation as cited. I find that the condition of that violation constitutes a threat to the public health, safety, and welfare. I'll give the respondent 5 days to comply. Thereafter, the city is authorized to enter the property, abate the violation, and assess the costs.
Matter number 25, case number CE 21060147, case address 1615 39th Street.
City of West Palm, Officer Williams, City of West Palm Beach Code Enforcement. This property was originally cited June 9th, 2021. The certified mail was sent out June 10th, 2021. That was received June 15th, 2021. The notice was hand-delivered to the property as well as City Hall posted on June 17th, 2021. To date, I've had no contact with the owner, but I did speak with his daughter. They were originally cited for 34102-A, 78-6, and 94-482-A. As of this morning, 34-102-A and 94-482-A have been complied. The only thing they have left to do is the 78-6, which the daughter did say that they are working on. So the city requests 10 days to bring that into compliance or a $25 a day fine thereafter.
You had the trifecta on notice with this certified mail and hand delivery and posting. So you do have proper notice. Based on the testimony and evidence, I find the property has complied with the violations it was originally cited with, except for 78-6 regarding numbering standards, which remains in violation. I'll accept the city's recommendation, allow 10 additional days for compliance of that outstanding violation. After that, daily fines of $25 per day until compliance is achieved.
Thank you, sir.
Thank you very much. You want to move to the 11:30 agenda?
Yes.
Okay. Do we need, anybody to take 5 before we?
If you'd like.
I'm good. I'm happy to
I'm
give
okay.
a little recess. We're good? All right, we'll just keep, we'll press on. Good morning, everyone. We're moving on to our 11:30 other matter agenda. These are probably all requests for lien reductions. If you were not here this morning when I swore in everyone who was here for the violation cases, I do need to swear you in, as your testimony at this hearing needs to be under oath. So if you're going to be speaking to me about any of these matters, please stand and raise your right hand, and I will swear you in. Thank you. Do each of you swear or affirm under penalties of perjury that your testimony today will be the truth, the whole truth, and nothing but the truth? Thank you very much. You can have a seat. Please silence any cell phones that you may have on you so they don't interrupt the proceedings. That will be appreciated. When your case is called, please come up to the podium to my right. The way we will proceed is that I'll hear from the city first. The city will give me some background information on the case and the property and the status of the lien after I've received that information, and it'll then be your opportunity to tell me about the request for the reduction. If you have documents or anything you want me to look at in terms of documentation or photographs, that would be the time to produce those, and I'll be happy to look at those. Once I've heard everything about the case, I will enter an order that resolves the matter in one form or fashion. So let's go ahead and get started.
Other matter number 10, case number CE 21050283, case address 550 South Rosemary Avenue, Unit 236, regarding Cooper Blues.
Good morning.
see
Sergeant
this
Goldman,
isn't
City of
even
West
a
Palm Beach
leader.
Police. On Thursday, April 2nd, 2021, I was working a undercover operation designed to check point-of-sale vendors that they're properly checking ID prior to selling alcohol. At approximately 23 hours, confidential source entered Copper Blues at 550 South Rosemary. Upon entering the establishment, they went to the bar, purchased a Michelob Ultra from a white female white female bartender wearing a black shirt, black pants. They were not asked to produce any identification and they were sold the beer at that point. I was able to view the entire interaction. I find them in violation of City Ordinance 6-12. This is their second offense. However, they've helped us out with a couple cases here recently. We asked that we just do the $250 fine instead of the $500 fine.
All right. Thank you, officer. Let me come over to respondent. Sir, if you could tell me your name and address, then you can tell me about the case.
No problem.
It's Anthony Close. It's 550 South Rosemary, Copper Blues.
Sir, how are you related or involved in the Copper Blues?
I'm the general manager.
And does the owner or general manager know that you're here?
I am the general manager. Yes, my owners do know I'm here. They're just not in town.
Very good. Thank you.
No problem.
Go ahead.
Okay. I'm familiar with the case he's talking about. It was a woman named Brooke who did serve. We're very proactive with IDing. Obviously, this case doesn't justify it. We're very, I think my staff's really great about it. They come to me nonstop. We're definitely checking IDs. I do training courses. We just had one. Or I have improv also. So where both my staffs go through an alcohol compliance and they have to look over IDs and take a training course on it. That's about all I have.
All right. Well, I will tell you, I can count on very few fingers the times Officer Colvin's come in here and talked about, being cooperative and with other matters. So that I think is important, and I know the city appreciates that. So while I will find, based on the evidence, that there was a violation of City Code 6-12 and that it was a second offense, I will impose the recommended $250 fine instead of the maximum $500, which I could have imposed. So
Okay.
Thank you. Thank you.
Special Magistrate, is there a time frame you want to put on the order to pay?
30 days
Okay.
to pay.
All right, thank you.
Thank you.
Other matter number 15, case number CE 21060014, case address 730 21st Street.
Hello, how you doing? Rudy Jean, Code Enforcement, Sanitation Department. I rode up 730 21st Street on May 26, 2020 at approximately 11:26 a.m. She was cited for 74-4 illegal dumping at 74-483 maintaining adjoining right-of-ways.
And then it looks like it was picked up, but then you issued the citation. Is that?
No, we picked it up. I mean, it was an immediate abatement because there were broken glass and it was left on the street. So we had to have our guys come by and pick it up ASAP. Abatement meaning it causes harm to the public welfare.
Okay. And then
it wasn't necessarily on her property, but it was on the right. Actually, it was next door at the vacant lot, but we found mail within all that stuff, multiple mail as well, showing 730 21st Street, showing the address.
All right, and then what is the remedy that the city is seeking?
$300 fine for pickup.
One time $300 fine?
Yes, sir.
Is this a a repeat offense for this property? Is this the first time?
Well, we've wrote that property up plenty of time, but this was the first time we were able to find evidence to see where the illegal dumping was coming from, and it was coming from exactly next door.
Okay. All right, thank you very much. Let me come over to respondent. Yes, ma'am, if you could tell me your name and address, then you can tell me about the case.
I'm Marika Osman. I'm the owner and manager of that duplex. So the duplex is next to that empty lot, what belongs to the city. So that garbage was on the city's property and not on the duplex property. They find those mails and they find me for $300 because the address on the mail is 730 21st Street, but the name is not my renter's name. And I have the leases back for 5-6 years. I never had anybody with that name. So I don't know how that mail get there. My renter didn't put the garbage there. This is what they said. And they want to find me. So I'm not responsible for any garbage what is on the city's property. And beside that, they put the notice on the top of the towing company's sign. This is impossible to see. They never send me certified mail or something to be able to do something. Even if it's not my property, this is city's property on the corner.
All right, let me have the city respond to that issue.
Well, immediate abatement means that we have to pick it up right there on the spot. There's no 24 hours given to correct that violation simply because there were broken glass. Any pedestrian could have walked on that glass and got hurt, and the city would have been held responsible. So therefore, our department go ahead and pick all the refuge up ASAP as soon as we put it in the system. So there was no time given, but the citation was posted on the property.
All right, and then there was a photograph with a series of, that one. Is that the address of the respondent's property?
Yes, ma'am. Yes, sir. Sorry. All four of the mail has 730 21st Street.
Yeah. Can you go back to that picture and freeze it there so I can? Yeah. 730 21st Street.
I can show you the list, who is my renter now and who was before.
Okay.
So nobody by that name. So I don't know why the city didn't find that person and find that person. Why they want to find me, the next building?
Magistrate, may I speak?
Go ahead, Mr. Posner.
Okay, the sanitation case, to clarify a few things, sanitation cases, it's actually a citation, not a notice of violation. There wouldn't be any certified mail. There's no 10-day notice or anything like that. It's not actually a $300 fine. The $300 is a pickup fee for picking up the pile that was put there. And on the matter of mail, the name of the person the mail was sent to isn't relevant, just the address is. We get wrong mail for people at all our homes all the time, and we dispose of it.
So has the $300 already been?
It's been billed out, yes.
They send it to me.
I understand it probably hasn't been paid, but it
hasn't been paid. It's been invoiced, and as per city code, she has a 30-day appeal period, and that's what this is.
So this is an appeal of the citation?
Yes, sir.
Okay. And I was just pulling up the code section, so you clarified that for me. Thanks, Mitch. Thank you very much. All right. What else would you like to tell me, ma'am?
Do you want to see the lease, what I have with the present renters and before? I can show you the leases. Nobody is but that name. So I don't know who is that, how that mail is there, and what kind of proof is whatever address is there, why I have to pay for that garbage. Because that is empty lot in the corner, and people are leaving the garbage all the time there, all the time.
Let me ask the city, where was the pile of debris that was picked up in relation to the actual 730 21st Street?
The pile was literally right next door to our property.
Can we go back to the picture that shows? Okay, so
And
there's
it's
the.
on the
I have
property is
better
located on the
pictures.
left.
Just a minute, ma'am.
Sorry.
I can only hear one person at a time, and sometimes I'm not even good at that. So,
With that photo, as you can see where that orange and white van is right there.
Yes.
That's where her property is, and the
Okay.
pile was
No,
right behind
no.
that beige vehicle right there. So her property is right there, and we've been having problems with this property for a while, but we haven't been able to see where it's the trash is physically coming from. This is just something that's just starting up with that refuge that we found there. Probably if we would have left that for like another week or two, we probably would have had a lot of furniture there as well, which we deal with on numerous occasions.
yes, ma'am, go ahead.
I have 2 pictures. You can see how this is, if you want to see those.
Okay, why don't you show those to, I don't know who wants, Mr. Posner, do you want to look at her pictures before I see them?
So on those 2 pictures, you can see that the city property is next to mine. And that garbage was on city's property and not on the duplex property. And people leave all the time garbage there.
No objection.
All right.
I'm not responsible for that.
All right, thank you, ma'am. Without objection, we have 2 black and white photographs. One shows the sidewalks that intersect and the light pole in the foreground with the building in the background next to the tree. The other's a closer-up picture of, looks like a slab that was on that lot. So those will be made part of the record for this case, ma'am.
Yeah, that slab is not mine too. This is on the city's property. That concrete slab.
Okay. So the vacant lot is city-owned property?
Yes, sir, it is.
All right. Is there anything else, ma'am, that you'd like to tell me?
You know, in the future, if the people leave the garbage there, they will come all the time because I'm the next door property, so I have to pay for that. I cannot prove that, but they cannot prove how that mail that there. They don't have picture of the renter that put the mail down. They don't have picture of that who put the garbage there. This is not the proof, and I am not willing to pay for this. And in the future, they will come all the time to me because it's next door property.
All right, thank you. Anything else from the city on this?
Magistrate, it's very common practice to trail garbage back to a location based on what's contained in the trash. It's not unique to West Palm Beach Sanitation Department. It's not even unique to West Palm Beach's police department. They do the same thing when they're looking for it. Clearly, it's up to you to decide whether or not it's evidence of coming from there. And in response to whether she would always be billed, that's only if a later pile had evidence tracking it back to that property. It's not automatically going to be billed to that property anytime there's a pile because this time there was mail.
All right, thank you. Okay. So, in this case, we have, yes, the debris or the garbage, the trash was adjacent to city property, but the city property is on a corner. The only other property that's even close to being adjacent is the respondent's or the appellant's property, and the contents that was picked up clearly contained mail from that address, and only that address. It wasn't as though there was mail from any other address. So based on what I've been presented with, I am going to uphold the issuance of the citation in this case. I'll sign whatever order is required for that process. Okay, thank you very much.
Thank you.
So, what's happening? I didn't understand. So I have to pay for it, or what? I don't understand.
Yeah, I'm upholding this citation. I'm not overturning the issuance of this citation based on what I've seen this morning.
Okay.
Thank you very much.
Magistrate, I apologize. Would there be a certain time period for payment of that
whatever the city code require. I'm upholding the issuance of this citation.
Okay.
I'm not
Very
attaching
good.
any additional requirements. So whatever city code requires, I'm upholding that.
Thank you.
Other matter number 11, case number CE 20060210, case address 6000 Pinewood Avenue.
Whenever you're ready, Mr. President.
Rich Posner, Code Enforcement. I'll apologize ahead of time. I think it's going to be a long day on this stack of lien reductions. Case ending in 210, address 6000 Pinewood Avenue. Date order 10/7 of 20, fine started 10/28 of 20. Ran for 141 days, total $14,100, $100 a day. Date of compliance 3/18 of 21. Property's been owned by the same owner. Property's been owned by them since January of 18, in which time we've had 7 cases open on that property. So we're talking about a city-managed property. Applicant mitigating circumstances blames the tenant, but there wasn't even a rental license on this property until March of this year. City's asking for 50%.
50? 50?
50.
Thank you. Okay, yes, sir. Go ahead and tell me your name and address, please, and then you can tell me about the request for the lien reduction.
Sure. Jeffrey Cozy. The address is 6000 Pinewood Avenue, West Palm Beach.
Go ahead.
Yes. I was not aware that I had a running lien on this property. I've have issues with my tenant, and he did bring up that I did not have a rental license. I did not know. I never owned a rental property in West Palm Beach before, so I did not know I needed a BTR, is what they call it, I believe, business tax receipt. Once I was aware of it, I went ahead and applied for it and got it. Paid for that, and I'm asking for a lien reduction because I've had a tenant that has been uncooperative, and I wanted to evict my tenant after there's been some multiple violations, and I was not able to do so because of a pandemic. So it seems like now I finally have the tenant kind of going along with the program now of not keeping trash out, keeping the house nice. I'm a real estate broker as well, and so I basically went to him and just said, hey, you can move out. And then once he saw what rental prices were, I think he finally now has gotten with keeping the property in compliance with the city. I believe I may have missed a hearing or something during pandemic that was on Zoom or something like that, which I wasn't even aware of a hearing. The only time I found out that I did have this running lien is when I went to sell another house that I had, another property that I had in Boca Raton. And once I found out that I had this, that's when I asked for the lien reduction. I've had other issues with the property. Every time you guys have come out and asked me to do something, I've done it in a timely fashion. I have a timeline here of what I've done and when I've done it, and the expenses that I've already paid. I've paid for, due to the proximity of the property, it isn't a dead-end street. People do drop trash. It's kind of similar to your other case. My tenant said it wasn't his. It was a he said, she said. I got charged. I just paid that, $309. I had to do fence permit, $95. I had to re-sod because there was some pavers on the side of the house, which I just found out maybe like 2 weeks ago. Had them removed. I had it sodded. That was another $500. Even to come in front of you guys is $200. I feel like I've already paid the city. I pay my taxes. I think this lien came out of nowhere, and especially because I couldn't even get my tenant out if I wanted to. I'm thankful that now he's finally taking care of the property. I don't need the city. I have rental properties also in Broward County. I don't have these issues. it's just, this is a tenant issue, and I feel like he's working with me now, and I'll be able to keep the house in compliance. The compliance officer, I've been out there, I've met him out there, Mr. Watkins, I believe is his name. I've met him out at the property several times. Every time I get a notice, I meet him out there, and my tenant's usually not there. I think doesn't want to speak with anybody about it, because, I don't know if he's not being truthful about leaving trash in the street or not. He says it's not. I guess I have to take his word for it. But like I said, I'm asking for a lien reduction because of the fact that I have a tenant that I can't get out of my house because of pandemic, and every time I've gotten a violation and known about it, it's been handled in a timely fashion. I've painted the house. You guys asked for, trash to be removed. And there's also another issue. Trash kind of blows onto the street. It's right next to a railroad track. There's an empty lot, and trash comes onto the property. So it's a constant cleanup, and that's basically what the tenant now is dealing with, and we're dealing with, and that's why we're here today.
Okay. Mr. Posner, can you tell me about the 7 cases that you earlier
That's the
testified?
screen we just brought up. Everything above that blue line would be since he took ownership. Outside storage, clean and sanitary. There's going to be more violations inside the case. That's just the beginning of the case description. Outdoor storage again, broken window, garbage can placement. The top one is the sanitation one, probably the one that he was referring to. Bottom line on all of this is what he said. Every time he's gotten a notice, he's responded. He may have missed this one. It was certainly sent certified mail and posted to property, but there shouldn't be in every time. He's supposed to be more active in managing his property and his tenants. Clearly, he's had an issue with the tenant. Not disputing that remotely, but as the magistrate is aware, that's all too common and not the city's issue, nor the city's job to manage it for them.
Did any of the other cases have to be brought to a hearing?
No, sir, just the one.
Okay.
And I couldn't verify on the spot whether or not that date was a Zoom hearing. It's around that time. It's certainly possible, but that wouldn't have changed how we did notice for it.
Right. Okay. All right. Sir, any final comments?
Like I said, this is kind of out of my hands. I've been dealing with an unruly tenant, and I appreciate you taking that into consideration. And as Mr. Posner just said, every time that I've known about something, I've handled it. I don't rely on the city to manage my properties. And Mr. Watkins says he drives by there every single day, and which is the other code enforcement officer that cited the property originally. And I let my tenant know that. I told him that he can't hide from the city. They're there every single day driving by. That's his route. So I'm hoping that he's on the same page and we don't have to ever do this again.
Okay. So we have a $14,100 lien based on the testimony that I've heard and about this case and this property. I will reduce that lien to $3,000. How long can you pay that within 60 days? I can give you more time than 60 days. I just threw that out there as a...
I do ask if you could maybe reduce it a little further, and the only reason I'm asking that is
and I'm not going to reduce it further.
Then I won't talk. That's fine.
I'll give you more time. I can give you...
I can pay it whenever you want.
All right, we'll say 60 days. Okay, thank you.
Thank you.
Other matter number 7. Case number CE, hold on, oops, I'm getting there. Excuse me, case number CE 18090396, case address 1104 State Street.
Good morning for 3 more minutes. Whenever you're ready, Mr. Post.
It's always morning somewhere.
Indeed.
Case ending in 396, address 1104 State Street, date ordered 11/7 of 18. Fine started 11/22 of 18, ran for 746 days. Total $74,600, $100 a day. Date of compliance 12/7 of 20. History is 5 cases on this property. We had to go through 5 other properties as well. There were 10 more cases in the history under that ownership there. The only mitigating circumstances given in this is there were delays due to COVID. Magistrate, we're going to hear a lot of that in the months and probably years to come, and a lot of times it's going to be an actual factor in this case. But when you consider over 600,000 people are dead in this country from this pandemic, to use it needlessly as an excuse for something as this, the violations were trash and debris, overgrowth, and the trash can sitting in public view. The fine started 11/22 of 18. I'll say it again, 11/22 of 18. The state of emergency in Florida started in March of 2020, and he's using COVID delays as the reason for why this went on. The city's asking for 50%.
Same owner?
Yes, sir.
I assume based on your testimony?
Yes, sir, same owner. Owned since 2014.
All right, let me hear from the applicant. Name and address, and then you can tell me about the case.
My name is Christina Morales. Sorry.
It's okay.
My name is Christina Morales. I'm personal assistant to Procopius Panagakos, who's the owner of said property. As assistant, I'm the one who had worked on the violation. The matter was rectified actually in December of 2018, prior to the pandemic. I have faxed confirmation as well as follow-up emails done in January of 2019, also prior to the pandemic.
Okay, is there documents you wanted me to look at?
Sure.
Why don't you show those to Mr. Posner, and then I'll take a look.
Sure. Is this the same copy?
First notification to the city was December 6th, 2018. I have a fax confirmation to the Department of West Palm Beach.
That's December 6, 2018.
Yes, that's correct. That was first notification.
Okay, so let's just hang on one quick second. I want to let the city have an opportunity to look through this. I assume this has never been provided to the city before, right now?
Yes, it has, sir. I've sent it by email, and I also have the email copies along with the attachments, as well as my laptop to show that it was sent.
Clarify the question. I assume this was not provided to the city in conjunction with the request for the lien reduction.
Yes, it was, Your Honor.
Was this part of your application?
It was provided. Provide me for 1 second here. It was provided.
Sir, could you also state your name and address for the record?
Sure. It's Peter Koziel of Asseline and Burlow. I am the attorney for the owner, Procopius Panagakos.
Thank you.
There was a cover letter to Monique Williams of the Code Compliance Division of West Palm Beach, dated February 16th this year, and it's from my partner, Alan Krinsman, and I believe that included a copy of, it included a copy of the photos. And I have black and white photos, but they're the same photos that Ms. Morales has provided to the court. I can provide a copy of this cover letter.
I have my own set. Let me just stop you there. Does the city have any objection to these documents being made part of the record? For
No
the city?
objection. We'll respond when it comes back to us.
Then without objection, the packet of documents that was provided by the applicant is made part of the record. I assume we'll go through these, so I don't need to. All right, so why don't you go ahead and walk me through all of this?
Yes, yes, no objection.
All right, and I believe this would already be part of the record since it's in the file.
Yes, sir, that is in the file.
Okay. All right. Go ahead. Why don't you walk me through the folder of documents that we've just been provided with?
Mr. Paganagakis had informed me just after Thanksgiving of 2018 of 2 violations on 2 different properties, 1104 State Street and 1131 9th Street, both which I addressed immediately and had hired a landscaper to take care of both properties. I had received an invoice on December 3rd, had provided all the documentation for both properties. One property was resolved without an issue. This property, for whatever reason, it's still ongoing. I had assumed after numerous phone calls and emails and then received no response after January 29th of 2019 that the issue had been resolved as the first property had been done. On all emails, faxes, and conversations, I had provided all documentation supporting that we had been in compliance. And I also have a running on, it's included in the folder, of all the invoices where we continue to pay the landscaper to continue to maintain the properties.
Okay, so there was a January 25th and a January 29th, 2019 email to Mr. Cartwright.
Yeah, he was the inspector to 1104 State Street.
And in that, yeah, looks like you included the order that imposed the lien, and then you also provided landscape invoices, photos after work was completed.
Mm-hmm.
And then that was on the 25th, and then on the 29th. Okay, on the 25th, Mr. Cartwright said to call him at the number provided. And then you indicated on the 29th you were out of the office, called, left a voicemail.
And I never heard her turn back,
So you never heard anything back at that point?
neither by phone nor by email. So I had assumed, based on the other property, because I was working both in conjunction, and I know the other property had been completed, so I had assumed not hearing back, no news was good news, and that turned out not to be the case.
So you were corresponding about 2 properties,
That is correct.
and the other property was complied out.
Both were complied, both were worked at the very same time in conjunction. One was confirmed and resolved. The other I stopped hearing back from, and there was no further correspondence either by phone or by email, and
you
I had
assumed that they were
assumed no
both
news was good news.
So you assumed both of them had been taken care of,
That is correct.
when in fact the lien on the case that I'm looking at right now continues.
And I never was aware there was a lien. I would have addressed it immediately.
Okay, so then there's a September 2019 email where you indicate that the owner of the property had received snippets. What does that mean? It says the owner has received email with snippets of a running violation.
Snippet is it's an app, it's a tool where you can cut out a portion of the screen. And I don't recall who sent it to him. I think it was his realtor. He was getting ready to sell the property or was considering it, and that's how we were notified.
What happened after the September 20th email to Mr. Cartwright?
I still have not had any further correspondence or conversations with Mr. Cartwright. I then reached out to John Fresca, who was the inspector for the 1131 9th Street that I had been working in conjunction and was very helpful in resolving the matter.
Okay.
And he is the one who then advised me that he had nothing to do with 1104 State Street and passed me on back to Mr. Cartwright as well as to Mitch Posner and Monique Williams, and that's how I began to deal with them.
If I can ask, at what point in the time frame was that?
from September, after dealing with John Cartwright. If I have, I don't know if there's any Wi-Fi here. I didn't bring that correspondence with me. Is there any way for me to access my email from here?
Isn't there public
yes,
Wi-Fi? There should
there's
be
a public
Wi-Fi.
city Wi-Fi.
And before we go there, so I have,
Maybe I can simplify it. Was your contact to me before or after the lien reduction application?
Was before the lien reduction. You provided me the lien reduction application.
From the initial, okay. That suffices, sir.
Okay.
so those are the emails. There's a stapled
I stapled the fax that I had. to keep
five-page
it
fax that's dated.
It's actually only 4 pages. The first one is confirmation.
Right, the transmission log,
Then there was a cover
fax
sheet.
cover sheet,
Yep, and 3 pages behind it.
notice or the order finding the violation, and then 2 photographs. So this is dated, the transmission log's dated December 6th of 2018. Tell me, tell me about that. What is this fax that I'm looking at?
I was told to prove that we had been in compliance, and I was given that fax number to send over to them. I sent it over. I cannot recall the details. I usually follow up with a phone call. So I would assume and believe that's what I did, and was
You were
told that they
showing the
needed time to
photographs
work
that
on it.
That the grass had been cut, and
Yes.
it looks like the trash
Trees had
can
been
is in the
trimmed,
back.
grass had been cut. We took care of where the garbage was placed it further back.
There was an enclosure for the gate.
Yeah, there was a gate there.
So it was placed back
Well,
behind the gate.
fence, not really a gate. The gate was broken.
Magistrate, if it'll help, we'll stipulate that those things were sent.
Beg your
We're
pardon?
not disputing whether or not she sent any of those things. The emails or the fax.
No, I understand. So the order in this case required compliance within 15 days, by November 22nd. And then this fax was sent on December 6th, so.
Yeah, November 22nd, a fine of $100, which we are not disputing the $100 fine from November 22nd to whenever it was corrected. We are perfectly okay with that.
Okay. And then what response did you get from the city when you sent this in?
I didn't,
Okay.
which is why I then followed up in January.
And you followed up in January. My concern here is that the order directs the respondents to call or fax, which they faxed to the number they were directed to fax, showing photographs that they had taken steps towards compliance. And then a follow-up emails were done in January, and a reinspection was never done. So that's my concern. I mean, I'll have the city address that. It sounds like to me, what I'm looking at is the respondent did what they were supposed to do, and there was never a reinspection, and the lien just kept running.
Okay, as I said, we're not disputing whether or not those emails or faxes were sent. When this case first came to my attention, I backdated on everything, looked if there was any other way to comply it earlier, other than their emails and pictures, which are not date stamped, by the way. And I have no way from here, because I didn't research and based on a lack of response, I have no way to look from here to see if and when the officer responded to any of that. I have no knowledge of that. I did not research that. What I researched was on the application, state reasons, be specific as to why a reduction should be granted. And they wrote, even though the property was complied earlier than the compliance date stated in the case file, which of course is what they're saying, compliance would have occurred even earlier if not for the COVID-19 created series of delays that were out of the owner's controls. That's what we looked into. Now, if you want us to look into that, I do not have a problem pulling this case from today's agenda and rescheduling. But those are not the issues that we looked into. And I don't have the officer here. I would certainly have him here if I knew that was the response that we needed.
Well,
May I speak?
This is the rare case where somebody has appeared and they have documentation that shows that they did what they were supposed to do in terms of.
And twice she said she assumed it was complied. I don't need to finish that thought.
So, you know, based on what I'm seeing, at worst, the property was in violation for a couple of weeks.
That's correct.
But certainly not for the period of time that it took to accumulate a almost $75,000 lien.
May I add one more thing? In response to your investigation, I would have to look in, because I did not bring that documentation, but I can find it through my emails. One of the requests given to me after September of 2019 was to show that we had remained in compliance, which I provided Excel spreadsheet that was provided to me by the landscaper of all the dates and invoices that we had paid pertaining to that property.
Unfortunately, what I don't have is
Beyond the
anything from the
transaction
city
list.
to corroborate those facts whatsoever. We unfortunately see cases all the time where people can't show us such invoices, they've paid such invoices, and at the same time, we have pictures showing, no, it wasn't. That mostly happens with chronic nuisance cases. But unfortunately, just having the invoice doesn't corroborate anything.
All right, and as I said, this is, yes, people come with invoices all the time, and it's not clear to me, though, that, I mean, the fax transmission log shows how many pages were faxed. It was right after the case was heard. The follow-up emails were a month after that. And
Yes, sir.
there's nothing in response on the city side.
I agree, but I have not been able to research that yet.
The admittedly rare case where it looks like somebody did what they were supposed to do and something, I'm not saying anybody did anything wrong, something just slipped through the cracks or something. That's really all I'm
occurs, it
saying.
happens, we're human.
So, and, you know, Mr. Posner, as you pointed out, you know, this is not earth-shattering kind of stuff. It was garbage can placement and clean and sanitary and excessive growth. And the photographs that are attached to the fax show that the yard was cut and the garbage can was put away, and I don't see any debris in the picture. So I think had the process happened the way it was supposed to happen, somebody would have gone out, re-inspected, and there would have been a couple weeks' worth of fines. So, is there anything else from the city on this one? Okay, so, I mean, what I'm going to do is reduce this lien to November 20, so whatever, November 23rd. Beg your pardon? So how many days was November 23rd until December 7th? Yeah, that would have been
14.
the following day.
14 days. 16.
So, okay, so I am going to reduce this lien to $1,500 payable within 30 days. I
Thank
think
you very much,
based
Your
on
Honor. I
the
appreciate
evidence
that.
that I've been presented with.
Thank you.
Okay? All right, thank you all very much.
And other matter number 1, case number CE 19100-260, 1410 9th Street.
I'm sorry, Kristen, can you repeat the address?
1410 9th Street, other matter number 1. I think it's the same. Yes, also other matter number 14. Case number CE 1908-0288, same address, 1410 9th Street.
So can we do them both?
Both of those together, yes. They own some other properties, but I want to keep the properties themselves separate.
Agreed. Okay, are we ready? Okay, go ahead.
Case ending, chronological order, oldest case first. Case ending in 288, 1410 9th Street. Date order 10/16 of 19. Fine started 11/18 of 19. Ran for 413 days. Total 82,600, $200 a day. Date of compliance 1/4 of 21. Case ending in 260, 1410 9th Street. 1/15 of 20 was the date it was ordered. Fine started 2/15/20. Ran for 348 days, total $34,800, $100 a day, date of compliance 1/28 of 21. This is going to be the same owner for both. The first one, that's 82,000. Normally it would be a 50% ask. We reduced that to 40% based on the close to six-figure lien. The second one, the city is asking for 50%. Mitigation is they corrected immediately, but they were cited 10/12 of 19, and the permit that was required wasn't even applied for till 12/28 of 20. So, I mean, that's over a year later between their supposed immediate compliance and any attempt to comply the actual case. And that was for case ending in 260.
So the violation was failure to secure a building permit and not getting the inspections and this was for an AC change out. So
That
you're
was,
saying
yes, that's
it's-
case ending in 260, and clearly, based on the date they applied for the permit, this was not.
Right, so that's what I'm making sure I understand. So the violation order occurred, and then it was almost a year later before the permit was applied for?
Right, the fine started 2/15, okay. The date ordered was 1/15 of 20, and it was originally cited October of 2019. They're saying they corrected it when they were cited, but the permit application didn't come in until December of 20. So over a year since they were cited and over
Cited in
11
October.
months since the date ordered.
Yeah, so cited late 2019, and then COVID hit, and whatever happened, and then it was late
Cited
2020.
October of 19. It went to hearing beginning in January, so still 2 months before there was even a
So the
state of
hearing was
emergency.
in January.
Cited in January. Fine started in February, still a month before there was a state of emergency in Florida. No permit application till December.
Okay, I gotcha.
The other case, they didn't give any different mitigating circumstances, just complied immediately. They were cited August 14th of 2019. Prohibited vehicle, no rental license. When they applied for the BTR, it was October of 2020. That's 14 months later, so there's no citing immediately.
So August of 19 was the case.
Cited August of 2019, went to hearing October of 2019. Fine started November of 2019. Rental license application came in October of the next year.
Okay, I understand.
So in neither case was there anything showing an attempt to mitigate this immediately, let alone what they wrote, which is it was corrected immediately. So the city's asking for 40% on the earlier case and 50% on the case ending in 260.
Okay. All right, yes, ma'am, if you could tell me your name and address, and then you can tell me about the request.
Yes, my name is Diane Villeneuve, and I reside at 619 4th Street in West Palm Beach, Florida.
All right, and are you the managing member of 23 Washington Street LLC?
I am not a managing member. I'm a real estate agent and property manager.
You're the property manager for the property?
Yes.
Okay.
And the listed designated agent as far as the lien reduction
Okay,
goes.
go ahead.
Yes, so the reason for the delay are multiple. One was simply that unfortunately, the owner, who is from New York, wasn't out of town when the notice was sent and was not received and brought to my attention for several months. And we complied immediately. The truck was something that the tenant at the time told me about, and we made sure that it was removed. There was grass that was cut right away. It happened recently again. Twice we were mentioned about grass, and we took care of it right away. Now, the one that was delayed, the AC, is because the tenant, and I have a copy of the eviction paper, became non-cooperative, and we could not go into the house, and I could not send the AC specialist. I could not take care of filing for the permit for the AC. So we did it as soon as we could, but yes, that is correct. It took quite a while until the tenant moved out and we had access to the property, and then we immediately applied and took care of that.
Okay.
Can I ask a question, sir? When was the AC put in?
The AC was put in, I'm not sure exactly. We're not contesting that it was installed without a permit. There was a violation, and we paid for that violation. I believe we were charged several times the price of a permit. The owner at the time, did not realize that he needed a permit. The AC was replaced in two parts. First, the outside, so he thought it was a repair, not a new installation. Whatever the reason, we don't contest that. We just applied, and we got it done properly, and we closed that permit.
Any other questions at this time?
Question, no, just comment. I mean, as the property manager, it would certainly be her job to know it needs a permit ahead of time. And the mentioned delays aren't very relevant. The application specified corrected immediately. It clearly was not corrected immediately. And as far as the grass getting cut goes, neither of these cases have anything to do with cutting the grass. So thank you for cutting the grass, but we didn't actually cite for that in either case. The only other thing I'd like to point out is, I mean, this is getting taken care of now because the property is currently listed for $349,000.
I have a question on the case ending in 288, which had a rental license and certificate of use violation. Were there prior rental licenses for this property before this violation in 2019?
The case history under ownership is 3 cases. Monique, can you bring up the main page? I don't have down here what it was for, so you can bring that up.
Ma'am, I mean, it looks like you acquired the property in, 2017?
Correct.
And was it a rental property right from the start?
No, we we did some remodeling and attempt to sell it. We're not happy with the kind of price we could get at the time. We got the tenant that was there for over 2 years had a lease with option to buy. It was actually started as an early occupancy agreement that turned into a lease because all of a sudden his approval letter was not sufficient. You know how approval letter, we thought we were selling the house, and it turned out into a rental.
Did you ever get a rental license from the city before this code enforcement case happened?
Yes. Okay. No, you mean before this code enforcement happened? I guess not, because, I mean, it's just that we thought we were selling the house. We didn't think we needed a rental license. It was supposed to be a buyer, and then he didn't qualify. At that time, we should have got our rental license, and it was just an oversight.
Okay.
As we stated time and again, the biggest problem code enforcement has in the city is rental properties. It is incumbent upon the owners and whoever they bring in as property manager to do these things correctly and avoid all this. Standing by our request for 40% and 50% on these two.
Okay. All right, ma'am, is there anything else you'd like to tell me?
First, I want to thank all the staff. I talked to Mr. Cartwright, Ms. Saint-Hilaire. All the people are very helpful. A lot of time I get notification and it doesn't come to here. I've never been here before because I do things right away. This got out of hand because the owner was out of town. So that's all I want to say is that, we just agreed to our responsibility on this. However, the punishment should not be more than the offense. We did the very best to take care of things as soon as we were aware of it. Thank you.
All right. So we have 2 cases. The first one, we have a lien of $34,800, and that's the building permit case. And then the second one is the lien of $82,600, which is the rental license case. I'm going to agree to reduce, we'll do it this way. We'll do $3,000 on case ending in 260, and $7,000 on the case ending in 288. So the total is 10, but it's split between the two cases. How long will it take you to pay that, ma'am? I can give you up to 12 months.
Yes, that would be great.
12 months?
Yes.
12 months.
Probably do faster, but it's good to have the time. Thank you.
Okay?
Yep,
Thank
thank
you.
you. We're just getting rolling here.
Okay, and other matter number 4, case number CE08 120657, case address 1002 Adams Street.
So this, Jerry Beekler is going to join me as a co-owner. I do own this property with my ex-husband, Jerry, which we're
Okay.
still friends.
All right, whenever you're ready.
Yeah,
I have
give me 1 second, I gotta find the right one.
Oh, yeah, he's got to do his thing first. You can bring that.
Case ending in 657, 1002 Adams Street. Date ordered 3/18 of '09, fine started 4/20 of '09. Ran for 3,899 days. Total $389,900. Date of compliance was 12/23 of '19. It was $100 a day. This is a new owner. Normal ask would be 25%. Based on the amount, city's asking for 10%. 7 cases under ownership, currently under contract for $250,000. Mitigation is the previous, it belongs to the previous owner, and it was recorded after change of owner, but the lien was actually recorded in 2009, and this owner has had the property since 2016. So city's asking for 10%.
Okay. All right.
I'd like to bring you something.
Need to get, so hang on. So let me get everyone's name and address on the record before we begin.
Okay. Again, my name is Diane Villeneuve, residing at 619 4th Street, West Palm Beach, Florida, 33401.
Okay.
My name is Jerry Beekler. I live in Port St. Lucie, 1719 Southwest Leafy Road, Port St. Lucie, Florida, 34953.
All right. And just for my knowledge, how are you affiliated with the property?
Diane was invested with the previous owner, and he ended up being a very poor partner.
So are you a member of the LLC? Is that?
Yeah, Dad LLC is a IRA real estate fund that allows me to use IRA money for real estate investment.
Okay.
Okay.
Go ahead. You can tell me about the request.
Yeah, I just, so you can follow along.
So let me have you show them whatever documents you have to Mr. Posner first. Make sure city has an opportunity to see everything.
Okay, I guess the best. Jerry, come back. You can talk over here on the microphone. If you can read the statement, I think that's the best thing to do.
Yeah. I'll start with the statement. In October of 2017, Ricardo Pierre quitclaimed 1002 Adams to Dad LLC for $70,000. So between Diane and I, it was an $85,000 investment. We were told there were outstanding liens which should be reduced. Water liens could be reduced to $7,000-8,000. That turned out not to be true. We met with the attorneys at the city, and they said water liens and trash pickups are totally non-negotiable, even though they went back to 2006. So we had liens that accrued interest at 11-12%, all the way back to 2006. Then we paid taxes on the property. I paid taxes in 2006, only to find out that there was past due for 2014 and 2015. I went into the property office with Ricardo Pierre, and he claimed he paid them, but was never able to produce checks or proofs of payments. So in the records there, I have payments I made for 2 years totaling $7,149.61, plus the $3,000 plus payment I made in 2016 taxes. Shortly after that, the city recorded the title change on 1/3/2017, and they filed a foreclosure lien less than 2 weeks later. This only gave us about 30 days. We had to hire an attorney in order to ask for an extension. On March 14th, the city sent a letter stating that 1002 Adams had been declared a chronic nuisance property on May 9th, 2014, which was, 2.5 years before we purchased it. And it gave us until March 29th to submit an action plan for the property, which we did. The second page of the letter shows the 2016 total market value of the property at that time to be $55,878. The city reduced their attorney fees and the final settlement agreement, their fees to $2,875, and the settlement agreement was $18,442.84. This allowed us to then get water to the property and to begin on getting electricity to the property. This agreement still left unpaid water bills dating back to 2006, which I paid after a DAD LLC property was sold in Fort Pierce. In fact, this property that was sold has had a similar lien. It was a tax lien that was acquired by me and Jacobson Auction, and it had over a $400,000 tax lien for not being properly secured. We met with a citizen-based board, a tax lien board, and they reduced the penalty to $1,000. And so once I sold that, I was able to then pay the balance of the water liens at that point, which had been accruing interest, which was $15,647.37. The property, when we got it, was boarded up, no plumbing, no electricity. We put in hurricane windows. We ran electricity conduit to the concrete flooring, did baths, kitchens, plumbing, the sewer lines. There was, for some reason, there was 3 meters on the property, even though it's an up and down duplex. So we had to pay $1,000 to cap one of the meters. And that increased the cost of the tax liens because we were being billed for 3 meters, and I'm not sure why there was a 3rd meter. In fact, the property had an extra address, which was 1000 Adams. That has since been corrected and changed, but it ended up being quite a quagmire. Bottom line, we've lost money on the investment, and the data, real estate is almost depleted at this point. I printed a picture from Zillow last night, and the second page shows that the estimated market value on recently sold property is $166,400. And we've done the best to maintain this property. We've had problems with tenants. Sometimes with COVID, one of our tenants way before COVID got cancer. She was the head cook for Red Lobster, and all of our tenants applied for workman's comp. I never received it. She was still employed when COVID hit, two times a week to come in and cook for a few hours, so she never was totally unemployed. She never got workman's comp. Tenant upstairs was a bus driver. She never qualified for some reason for workman's comp. Her husband was with, we have the Mets, I forget who it is, the spring training team up here. He was a lawnskeeper. He got laid off, of course. So there's been various obstacles for us and our tenants. So that's the human side of it.
Sure. I just want to make sure that I'm getting it right. So you've paid about $10,000 in back taxes, $15,000 in the water liens, and how much in the improvement?
No, actually
with 15,000.
No, but the settlement was also water liens. So I paid over $35,000 on water liens. And we were told when we met with the city attorney that those could not be lien reduced or negotiated.
Okay, and then what about, you testified that you made some improvements to the property, do you know?
Oh, yeah, we have all the permits. I mean, we did everything with permits. We basically rebuilt the inside. I mean, it's lovely now. It's the nice apartments.
What was the ballpark, the investment in the improvements?
I would say we have $250,000 into it.
Okay. All right. So, I mean, based on that testimony, you've invested or paid back taxes and utility liens in an amount that's comparable to the amount of this code enforcement lien, if I'm doing the arithmetic correctly.
Yeah.
Okay. Is there anything else you folks would like to tell me?
That's it.
Let me come back to Mr. Posner. You may have questions or additional.
Several things. No, did you get a copy of these documents already?
No, I have not
Okay.
seen.
No objection to the documents other than to point out the list pendants document is irrelevant because this lien had nothing to do with that.
Which one?
The one on top.
Okay. Let's see.
I'll let Arlene comment on that.
Special Magistrate, the list pendants is in a City of West Palm Beach foreclosure action, which is underlying here. The specific settlement agreement attached to that indicated that the code enforcement liens are not a part of the settlement foreclosure.
Okay, understood.
I just included it as part of the history.
Okay, so the respondent has provided a series of documents which include photographs of the property, utility billing, printouts.
I also have in there in an email, and can you bring this to him?
Has a copy of that?
No, he doesn't.
It's 21 pages. Okay. And then we have,
In there, you'll see, if you go down to paragraph 5, the last part between item D and item D1, the email correspondence from my attorney stated, the terms of settlement will include that all liens are released and water services restored to the premises.
I'm still going through the documents that you produced. All right, and I think this gets to the lien settlement of $18,442, and you're saying that that did not include that settlement did not include any resolution of this code enforcement lien.
Sorry. The foreclosure case did not include a
Okay, then
resolution
here's
of
the
any
settlement
code enforcement
agreement
liens.
itself.
Right.
This
And
lien
again,
was...
that did not capture what's before me today.
That is our position. Also, the position of the city was emailed to Mr. Buchler back in, I believe, November of 2020, also letting him know that.
All right, then. March 14th, 2017 correspondence on the city letterhead from Mr. Frasca regarding the transfer of the title to the current DAAD LLC and Rhodes Diane owners. Then we have property tax documentation and payment receipts. And then finally, another copy of the 2009 order imposing fine. So these are all original documents. If these are going to be made part of the record, we're going to have copies of all these. I don't think you want to give up your
that to you, yes.
originals.
We got notice yesterday that this was happening, and I was in dental work all day, so my chance to...
Can you go closer to the mic, please? I can't hear you.
I had dental work done all day yesterday, so I really didn't have a chance or the mood to... I got up early this morning to just throw this together. So otherwise, I normally would have copied it all. I just didn't have time.
Well, what I'm going to do, I will accept all of these into the record, but in order for them to physically be in the record, you're going to need, I'm going to give these back to you, but you're going to need to make copies and get them back to the city for them to be physically included in the record, because these are all your original documents. And if that doesn't happen, if for some reason someone needs to review this record in the future, this won't be in there.
Gotcha.
So I'm putting that burden on you to make the copies and get them back.
No problem.
I don't think there's really any other reasonable way to do it.
Magistrate?
Yeah.
Regarding the last page I handed to you, because that was separate, No objection to the email itself, except to point out that it references supporting documents that aren't attached to the email anymore, and also mentions a Zillow page showing a recent sale for another property nearby at $166,000. But if that's going to be looked at, our understanding is it's actually under contract for $250,000.
No, it's not on contract. It was on the market for that price, which is, tax value is different than market value. So it is a market value of about $250,000, but that transaction was canceled because of this lien. So the people walked away. We were no longer under contract. I do believe, though, that the property would probably sell for what we have invested into it, but not much more.
How long did this remain in chronic nuisance status?
Bring up the main page.
And that was the prior owner, though, either way,
I
right?
believe so. I just
okay.
need to see that, or bring up that page.
Yeah.
The city doesn't dispute any of the hard costs that, in fact, cannot be reduced, the water bill, and
Right.
I mean, that's standard procedure. But before considering, I forget the full amount he said they put into it improvements, we'd like to see some kind of documentation showing how much was spent on those improvements.
But do you know how long the city had this in chronic nuisance status?
I'm looking for that now.
That'll help.
It was opened in 2014. Can you?
It's on one of the forms there.
It was closed in 2018? Yeah, 4 years.
Was that Mr. Frasca's letter? Okay.
The
No,
letter
that's still
states it
like
was chronic nuisance since 2014. That's 7 years.
But when we acquired the property, I came to the city and I received I have documentation showing communication that we immediately start cleaning up, cutting the grass, and we applied for a permit and we started remodeling the property as soon as we acquired it.
City's not disputing the chronic nuisance case is closed.
This property also has an issue which I've asked to be addressed, in that there's an empty lot next door. We supply the garbage bags and the garbage cans because people congregate there on the weekends, and there's a store just half a block down that people buy whatever, and then our property gets trashed. And I've asked for the city to have a trash bag there, and they said, well, we can't do that because then we'd have to pick it up. So instead, on something that's not even my lot, we have garbage cans. I put trash bags there, and I go pick. I empty those trash bags whenever I'm down there.
I understand. I understand that is an issue, and it's not isolated to this property. Okay, is there anything else anybody else wants to tell me on this
Just
one?
to point out, one more in a string of rental properties that has us here debating this endlessly.
Any final comments from the applicant?
Yes. This odor imposing fine and lien, it says order respondent has failed to comply with special magistrate's order dated March 18th, 2009. That's when the $100 fine was put in. The order shall be recorded, and after 3 months, the city attorney is authorized to foreclose on the lien or sue to recover a money judgment. Why has the city attorney never done that? This was a nuisance for many years.
Real quick, that comes out of state law. State law requires a municipality to wait 90 days before it can even decide if it's going to foreclose. And then once that 90 days comes and goes, then it's their option. They don't have to. There's plenty. I could give you dozens and hundreds of examples of liens where a local government has the ability to foreclose on a lien, but for a variety of reasons, all theirs, they opt not to pull that trigger.
Because in the three properties I've done in St. Lucie County, the county or Fort Pierce in one case was pretty quick to put it on the market.
Well, different jurisdictions behave differently in terms of that. So
just a question.
Yeah, sure.
Just something that I was inquiring about.
Okay. Well, so in this case, we have a new owner of a property with a almost $390,000 lien. I appreciate all the money that you've put into this property, not only for improvements, but for back taxes and utility liens. So certainly there is and even the city acknowledges that there's a significant reduction that's warranted. I can't overlook, even though it was a prior owner, the fact that, you know, this property had issues and the city had to invest time, effort, and money into that to protect the public health, safety, and welfare. So based on everything I've heard, this will probably be one of those where nobody likes what I do, so that usually tells me I get it right. I'm going to reduce this $389,900 lien to $10,000, and I'll give you up to 12 months to pay that.
Thank you, sir.
Okay. And then you need to take these, and that would be fine. Yes.
Well, I'll make copies and I'll bring them back.
Other matter number 13, case number CE 19020026, case address 619 4th Street.
Okay, yeah.
Whenever you're ready.
Case ending in 026619 4th Street, date order 4/3 of 19, fine started 5/6 of 19, ran for 688 days. Total $137,600, $200 a day, date of compliance 3/24 of 21. Same owner, normal ask would be 50% under the circumstances. City's reducing that request to 25% based on the size of the lien. This was still accruing when they applied for a lien reduction, so it didn't even get resolved until after they said, hey, can we lower the lien? There were multiple contacts with the property manager throughout the case, before and after the fine started. There were debates with the case officer as to whether or not it was in violation, but the magistrate order had been issued. The only mitigating circumstance put down is violations were resolved promptly. I'll say again, this ran for 688 days despite contact before and after the magistrate's order, before and after the fines. So he's asking for 25%.
Same owner?
This is
Yes,
under that LLC, not that LLC, it's Hot LLC, which is a different LLC with the same owners.
Ma'am, for this case, could you put your name on the record again and address?
Yes, Diane Villeneuve at 619 4th Street, West Palm Beach, Florida, 33401.
Okay, I'm not clear on what you were saying about the same owner.
Pardon me?
What were you just saying about the same owner?
Oh, I said it's a different LLC. It's owned by Hot, HOTT LLC.
According to the record magistrate, Hot with 2 T's LLC purchased this property September of 2018.
Right.
This property was cited February of 2019.
Okay. Got it. All right, go ahead, ma'am.
Okay, so this is what the house looks like, the picture right now when we purchased it, and you saw the new pictures. We just like to improve the property, improve the neighborhood, do some landscaping. So very proud of what we did with this older home. What happened is that the violation was whatever we were fine. Mrs. Cassandre Saint-Hilaire was the code officer on this one. We received the notification right away, and we complied right away. I don't understand why this kept running. When I talked to Mrs. Monique William, and she told me that we were in compliance almost a year ago. So contrary to what Mr. Posner is saying, it was not supposed to be continuing to run, and the violation was for having the hurricane shutters shut down. So the same day we opened them, she said that we had to have at least 50% of the shutters open. And we needed to get the rental license. What happened is that we were deciding if we were going to rent the place or live in it. So because of that location and because of the violation, we decided that I was going to move in, which I've been living in there since. And we've, cut the grass. Actually, we laid some lawn in the backyard and started improving. The property was a pile of sand in the back, and now we have a fence, and it was already fenced, but we cleaned up the fence and put some landscaping. And I don't understand why that lien kept running, because we complied right away with whatever was, the issue. I did apply for a rental license just in case, but then because I moved in, I was told I didn't have to pay for the license unless I moved out and decide that it was going to become a rental property. So I live there. I feel like that I'm a pioneer because I'm in the Northwest where there's a lot of crime, but I do enjoy this area, and I really feel that the city is trying really hard to improve the area, and I feel that I'm part of that. So, and I want to thank all of the staff at the city that are great and communicate with me and are very patient. Andrew and Susan told me that they'll probably give me a desk soon at the service.
All right. Anything else that you want to show me or tell me, ma'am?
No, not at this point.
Okay. Anything else from the city?
Yes, I did want to comment on Cassandra St. Hilaire, Code Enforcement Officer with the City of West Palm
Yes,
Beach.
ma'am.
For 619 4th Street, the reason that the fine kept running, the issue was with Miss Diane because she refused to understand what the code was stating for the rental license to be issued. She had, she was trying to rent it out to several other people that were not related. And I believe as it was zoned, it was a single family home. And as it was explained to her over and over again, that a family could stay there, people that were related. She wanted to rent out different rooms. And each time we told her that, she would not comply. She went to talk to planning and zoning. They told her the same thing. She went to the front desk. They told her the same thing. I believe there wasn't even an email thread that she sent both of us where we explained to her what needed to be done for compliance. She was not complying with that order. And then she said that she was going to live in there, never filled out an affidavit of non-rental, anything to prove that it would not be rented. So this is why the fines accumulated to where it is today. Not because Cassandra St. Hilaire did not want to help you or the city didn't want to work with you. It's because you refused to follow the directions we kept giving you. And that's what it is. And we've had the same issues not only with 619 14th Street, but some of the other properties that she's listed as owning as well. 10002 Adams Street, the property on 18th Street. Every time we told you guys to do something, you would not do it until you decide you want to do it. And then fines would accrue, and now we're right back here. That's the situation.
Okay.
Well, I'm shocked and sad that you feel this way because I never receive anything in writing, and I can show that my electric bill is paid by me for the last 2 years, and I do listen when people talk to me, and we have complied. It's not just me, it's my partners also, so I'm sorry if there was some kind of misunderstanding, but I did comply and I did understand, and that's why I moved in. Because I figure, well, this is the kind of neighborhood where I understand that the city is trying to avoid issue when there's like non-related people in the home. And once I knew that, I complied right away, and I can prove it. So I'm sorry that this is the impression that I gave. We've complied, and I think our tenant complied with and sometimes it's the same thing as the gentleman said earlier. Sometimes with the renters, I really disagree with the fact that I'm doing things when we feel like it. That is totally incorrect. We have also rent letter. I can show you dated and signed letter that my tenant signed once I'm informed them that he could not leave items on the staircase or could not leave garbage, not in garbage bag. I mean, we just specifically train literally our tenant to comply with the city. So I'm a little bit shocked and disappointed that someone is making those accusations after months of trying to jump through all the hoops that the city has put through. So that's like, I don't want to take this personally. I'm sorry if I'm getting emotional.
All right, thank you, ma'am.
Magistrate.
Anything else, Mr. Posner?
Yes, sir.
Yeah.
The city is past the point of shock on any of these. This is the third in a row with the same property manager that is before you where the mitigating circumstances do not actually match the facts of the case. In this particular one, we had the case officer on hand to point out that the statements being made to the magistrate were unfactual. The case notes bear that out. The city's asking for 25%.
Okay. All right, any final comment, ma'am?
That's surreal. I mean, that sounds like something personal. I mean, this is a business transaction, and I moved into the property. Those two other property are owned by different partner, and we've already resolved. You're making me into a bad guy. I have never been in trouble with the law. I have a real estate license for 35 years with not a single blemish.
Okay, so I'm gonna interject myself. I'm not interested in personal attacks on anybody. Nobody's calling anybody a criminal here. I'm not interested in a personal attack against
Again,
Mr.
I
Coates.
disagree with what is said.
I understand
I'm
you
just a
don't agree with what he
businesswoman,
said.
And, I mean, at this point, that's all I have to say.
Okay, so in this case, we have a 2019 case with a lien that's $137,600. Based on the testimony and the evidence that I have reviewed on this matter, I will agree to reduce that $137,600 lien to $20,000, and I'll give you 12 months to pay that. Okay, thank you.
I'm not the only owner of this property, so I don't know, is there some kind of appeal, or do I need to hire an attorney on this case? That seems excessive for having hurricane shutters open and having complied immediately once I knew.
Thank you, ma'am.
I knew. All right, well.
Have a nice day.
Yes.
Other matter number 2, case number CE 13070188, case address 247 Seville Road.
Okay. Yes, sir.
Case ending in 188, 247 Seville Road. Date order 10/2 of 13. Fine started 12/2 of 13. Ran for 1,942 days. Total $485,500. Fine was $250 a day. Date of compliance 3/28 of 19. This is going to be the same owner. The mitigation we have is it's the city's fault and was told no fine. We've had this before. This is a case where they were told that they're not being held responsible as far as the permit fees are concerned, so they're not being charged 4 times the permit fees. That is not the same thing as no fine. The owner respondent was at the hearing, so certainly knew that the order was, fines being instituted if they did not comply. Also blamed the contractor, but as always, it's the responsibility of the owner. This is normally a 30% ask. Based on the extensive size of the lien, the city's asking for 5%.
Yes, sir. Go ahead and tell me your name and address, then you can tell me about the request for the reduction.
Theodore Westervelt, 247 Seville Road, West Palm Beach.
Yes, sir.
May of 23rd of 2010, we signed a contract with Electron Solar Energy for a solar system to be installed. We gave them a $10,000 deposit and signed a 12-month zero-interest loan with Interbank USA, who was supposed to give Solar Electron 2 payments of $22,500. We were supposed to give signed authorization for those payouts. Unbeknownst to us, Energy Bank gave Electron Solar Energy the full amount right away. Christopher Quinn and Alonzo Electric, Florida State License 13003307, filed for a permit. They did pay a fee of $1645.55 for the permit fee on May 24th, 2010. I believe Electron Solar Energy got a permit for the city on April 27th, but that doesn't make sense to me. When I filed this lien reduction, I sent all those paperwork in with that. I hope that you have it.
We have everything sent in with the application.
Okay, cool. I don't know, I don't remember when the solar panels were installed, but on August 12th of 2013, Steve Pentek from the city gave us a notice of violation for failure to secure a permit. And I did appear here in front of a special magistrate, Wanda Lenhort, I believe, on October 2nd, pleaded my case. She told me to go see Robert Brown, the city's building department, because of the extenuating circumstances of my case. She assured me that there would be no fines levied against our property because we had been wronged by a state licensed contractor. I remember that conversation with Mr. Brown. He told me that there were drawings missing from the permit application. We filed those, and then I paid for the permit drawing review fees. And I believe that was the amount of $400 and change. Could be wrong. I was able to get a hold of Christopher Quinn after talking with Mr. Brown. He assured me that this project would be finished. Upon further research, Christopher Quinn had left the state and also had scammed 5 other families here in South Florida of money. When I couldn't get a hold of him, I knew that I was, excuse my French, screwed. So I took the panels off the roof and stored them in the garage. And then I put ads up on Craigslist to try to sell them, just trying to recoup something of $55,000 that we lost. On December 4th of 2018, I gave Cedars Electromechanical a $47,600 deposit for a contract to finish the installation. Cedars got a permit from the city of West Palm Beach, permit number 181-20883. The project was completed in April of 2019. I had no idea that the city was levying a fine on me, $250 a day, I swear to God. The only way I found out was we applied for a interest rate loan reduction last year, or January, I guess, this year. That's the only way I found out. So right now, we have invested $65,000 in this solar system that we will never, ever recoup. The good thing is, out of all this, is that solar system has now produced 12.5 megawatt hours, and we have saved the planet almost 20,000 pounds of carbon dioxide. But can I ask you a question?
It's up to the magistrate.
Okay. Did Solar Electron ever pay you guys for the permit fee?
The permits would not have been issued without having been paid for. So they must have.
Say that again?
The permits would have to be paid for before they were ever issued. If you're asking if they paid prior and then someone paid again, that's not something I've looked into. I have no information on that.
Okay. Because best of my knowledge, they did pay for the permit fee.
When would that be?
And the permit fee was $1,645.55.
No, I said when was that?
When was that? May 24th, 2010. And that would be in with the paperwork I sent in for the lien reduction.
Not something I've looked into. He could be correct. It's not something I would dispute unless I had information otherwise.
So you guys would have that with my lien reduction that I sent in. My wife and I tried to do something good. We got ripped off by a guy who now lives in Troy, New York. I feel like, and I understand, sir, because I have worked for an architect, I understand the permit process. But that was on him. We hired him to get the permit, to do the work. I made the assumption that he had done that and we were doing the right thing. And that's all I got to say.
Can I see the order finding violation in the case that generated this lien? Thanks.
Okay, that's the magistrate order and then the order imposing lien.
Okay. So you were at Mr. Westervelt, you were at the hearing in October 2013, and the magistrate ordered, found a violation of the code section that requires a building permit and required compliance within 60 days. Is that your recollection? I mean, that's what I'm reading. That's the order that the magistrate signed. That's what I'm reading.
Can you read that once more, please?
Yeah, so the 2013 hearing, you told me you attended.
Yes, I did.
That order required, well, it found a violation that work was done without a building permit.
Right.
And it allowed 60 days to bring that into compliance. Do you recall that? Okay.
No. It's like I said, I went and saw Mr. Brown, and I thought that had cleared everything up. And then that he had told me that it either take down the panels or find an electrical contractor to finish the job. And where we had just paid out $55,000, we obviously didn't have the money to finish the job, so I took the panels down.
Okay. And then there was that the only hearing you attended?
Yes, sir.
You didn't, so you were not at the December 2013 hearing? And that's the one where the fine was assessed. And the first magistrate was, or no, let's see. No, it was the same magistrate. Okay. But you don't recall the 60-day compliance deadline or any of that? Your
No, sir.
recollection was as you told me. Okay. All right, thank you, Mr. Posner. But then your recollection was you had hired contractors who applied and paid for permits, and
Yeah, and
then all the bad stuff happened.
in December of 2018.
Right. Well, what is that document?
Have you, I'll give it to you. But you guys have a copy.
That's between him and the second contractor that they hired to finish it.
Okay, so this is December of 2018. That's the 47. Okay. All right. Is there any objection to this being made part of the record by the city? I think you already saw this, Mr. Posner.
I already saw that. Yes, sir. No
Is this a
objection.
copy, or is this your original document?
No, I have the original here.
Okay, so we can make this an exhibit for today's hearing?
Yes,
All
sir.
right.
Magistrate?
So let me ask Mr. Westervelt a question. So at the end of the day, are the panels now installed, permitted, and operating?
Correct.
Okay. And that was with the last that was with these guys?
Yeah, with Cedars Mechanical, yes.
Okay. So they've been up for a while, you just weren't aware that the...
I had no idea there was a lien.
And that was 2018?
Correct.
Okay. All right, yes, sir. Mr.
Several things. The main issue is caused by two things. The contractor you hired in the first place, which we've checked and determined that no payment was received for the permits in 2013. I haven't had a chance to look to see if there are any other issues with the permit, but they certainly would not have been issued with payment still pending. And the other issue apparently is, what I'm getting from all this is Mr. Westfield didn't completely understand the hearing he attended and what the magistrate's order was and when the fine would start. In the end, the problems with the contractor are still the responsibility of the owner. The city does not dispute that had he realized it, he would have resolved this sooner rather than let it go on for almost 2,000 days. Given that sympathy, that the city's request is already to reduce it by 95%.
Okay. Mr. Westervelt, anything else you'd like to tell me before I bring this in for a landing?
Like I said, and I've got paperwork here from Yelp showing that the man ripped off 5 other families.
We have no dispute of that, sir. I believe you.
If I had known, believe me, I would have gotten my butt down here and paid, honest to God. And whatever the original permit fee is, I'll pay it now. Seriously, if I had known.
Can you speak into the microphone, sir?
Sorry, deaf in the left ear, don't do well. If I had known, I obviously would have gotten my butt down here and straightened this out. And I did not know. Also, I'm more than willing to pay the original fee for the permit. I mean, that makes sense, right?
Sir, if I had a DeLorean, we can go back in time, I would be happy to resolve it that way. That's not something that's available necessarily as an option unless the magistrate rules it that way.
Okay, so let me wrap this up. This is, based on everything I've heard, I like to think I'm a good judge of character. I think that you did what you thought you needed to do, and I believe that your testimony. This is a $485,500 lien. Nobody disputes that you had bad experiences with contractors. I think that was the case based on this testimony. I think you're probably going to get, based on the amount of this lien, you're going to get the deal of the day from me, because I'm going to reduce this to $2,500 payable within 30 days. I think that would cover the cost of whatever the permits were in the past. It's a huge reduction, but I think that based on everything I've heard, that it's appropriate for the circumstances.
Thank you.
Okay, thank you. Do we need to take a break? It's like 1:15, and we've been going since 9 o'clock, so I know we've got a few more lien reductions. Let's, how many more do we have before we get to...
Looks like 5 more.
2, 3. Well, you guys tell me. I can keep going. I'm happy to give everyone a break.
I'm happy to keep going.
All right, let's push through the rest of the lien reductions, and then we'll take a few minutes and get the rest of our work done.
Okay, other matter number 5. Case number CE11020347 5717 Pinewood Avenue, and same address, other matter number 12, case number CE10080517, again, 5717 Pinewood Avenue.
Okay.
Chronological order, oldest case first, case ending in 517-5717 Pinewood. Date ordered 9/29/2010, fine started 8/25/2010, ran for 15 days, total $750, $50 a day. Date of compliance 9/9/2010. Case ending in 347.
Just real quick, was that the same owner or was that a different owner?
That's going to require a long explanation that I was holding off on a second.
Okay.
You might be sorry you didn't take that break.
Never mind, go ahead.
There was a reason I didn't say it. Case ending in 347-5717 Pinewood, date ordered 4/6/2011, fine started 5/24/2011. Ran for 3,213 days, total $240,975, $75 a day. Date of compliance 3/10/20. That was a split order, so it also has date ordered 4/6/11, fine started 4/28/11, ran for 3,239 days. Total $242,925, $75 a day. Date of compliance 3/10/20. The city's position is that this is the same owner. I may be relying on the city attorney's help on this because just to get this far, we had to rely on them a great deal. We had also cited this property for no rental license. We were basically advised that the occupant, Mr. Dove, is part owner of this property. Therefore, they don't need a rental license. The legal department agreed that case was closed. The reason I bring that up is it's their contention that this is a new owner, except Mr. Dove, according to the mortgage that Mr. Dove provided, has been part owner and occupant of this dating back to the first case.
Okay. So
the city's position is that it's the same owner. On the $750, given everything else, 100%, 5%, I don't know if that matters given the size of the other two.
Well, that's why I
liens.
was trying to just at least get that one off the docket and then focus on.
And if you want to reduce that to $10, the city's not going to
We'll
object.
hear from everybody first.
Okay.
And,
The other two, the city's asking for 15%, 1.5 on each.
15? Okay.
And if you give me a minute, I've got a copy of the mortgage and a few other documents I'd like to go over.
Thanks.
Some of the pages of what we've received was hard to read. The agreement for deed starts on page 5.
Yeah, tell me what I'm looking at here.
It's dated August 23rd of 2010 and says, well, first paragraph ends with, and Victor M. Dove, hereafter known as the purchaser. This is what they have provided, showing they don't need a rental license because he's part owner. If he's owned it since that time, then this case is, both liens are the same owner. I also like to point out the only mitigation given on the application is the fact that it's a new owner, but again, that's not our position. The fact that it is a new owner, and again, that is not our position.
Okay. Let's hear from the applicants. Go ahead and tell me name and address, and then you can tell me about the request.
My name is Faith Hoover. The property address is 5717 Pinewood Avenue.
Yes, ma'am.
I am the property manager for Equity Trust Company, custodian, FBO. There's the numbers behind of it.
Okay, go ahead.
My name is Victor Dog, 5717 Pinewood Avenue.
Thank you,
West
sir.
Palm Beach.
Whichever one of you wants to begin, go ahead.
Okay, so basically what we're here today for is to ask for the lien reduction. There was a very large amount on that. As we were told, as he, Mitch, yes, was saying that we were told we do not need a rental, so I don't know if that one is still up in the air, how that.
Say that again, get a little closer to the mic.
That
so
we
I
do
can-
not need, like, we don't have to apply because he has an agreement for deed. So basically, which is different. He is purchasing the property from an agreement from deed, which is separate from somebody just being a tenant and just renting the property. He's actually becoming the owner of that property.
Agreed, magistrate, the rental license is not an issue for this hearing in itself.
Yes, no, there's multiple things. Yeah, there's multiple. All right, so it looks like from here that this started back in 2010. We've been working on this case for, I want to say, I have been involved, I think, from 2018, 19. So it's been some time with this property. 2010, he took care of the city fine. So basically, there was the windows that were boarded. They said lot clearing. They said there were certain things. Victor said, that, Mr. Mitch said that, because I did ask him, I said, some of these, I said, were before him, before Victor, before the owner of Equity Trust purchased this note, okay? He says it doesn't matter, whatever liens or anything that is on that property follows that property. So therefore, that means if it's with us, it doesn't matter if we was to, let's say we was to sell it, how I took it, we sell it, it goes to whoever else follows. Everything that was on there was took care of by Victor. Those were paid for. We're not disputing any of that, because the city had to come in and I guess they boarded, they, did lot clearing, whatever, and the other things that was on there. Our dispute is this: some of those fines were accumulating for years. It's 2010. Victor has worked very hard to get in compliance with this property. Would go in, it would be one thing, and then it would be something else. Then it would be, something just coming back nonstop. But anyways, moving forward, we are in 100% compliance. He's worked very hard, a lot of money put into this for that, basically asking for a lien reduction, because that's a very large amount.
Okay.
Large amount.
Okay.
Okay. I think it's page 2 of the documents I gave you, is an email from Equity Trust Company custodian. ETC is responding to the code violation. This property is not a rental. Please find the contract for deed, which in Florida is considered to be equivalent to a mortgage. That's the deed contract I've already mentioned.
Right.
Okay, so if this is the equivalent of a mortgage, then they're the mortgage holder, not necessarily the owner. That doesn't change the owner of record being Victor Dove, who has been there since 2010. I'd like to further add that their involvement was actually prompted by the fact that we did have repeated issues here, we just didn't repeatedly cite it because we can't cite for something already running fines. The legal office, because of that, sent out a notice of right to foreclosure February 18th of 2020, and that's when we started finally getting a response to finally close out the violations and they get the lien resolved. One second.
So 2020, I have the emails from 2000.
Thank you.
In other words, in order to get this resolved, the city had to send a notice of possible legal action. And again, this is the same owner. That remains the city's contention. We don't dispute their right to get a lien reduction, same owner or not, they certainly have that right.
May I ask a question?
Just let me
Okay.
look at this.
Yeah, because these go back from 19, so it has this.
Yeah. Go ahead.
My question was this: you said that did not respond until of 2020 taking care of these liens, because my emails go back from 2019
To myself?
to Monique Williams, to Robert Watkins. I do have emails. Let's see. I have emails right here that goes all the way back from 2019. So we have started with this since I've been working for the company and trying to come in compliance with Mr. Watkins, Monique Williams from 2019. And I'll see if there's any from 2018, but I do believe it's 19.
Magistrate, the city won't dispute that. The referral to the legal department certainly would have predated that, or it wouldn't have been sent out as early as February 2020. So probably something got crossed and all that. But it still went on since 2010 with, as far as the city is concerned, it's the same owner.
Okay.
And I never, 2010, basically, this has been a cure, from 2010. What I was saying, since I became, working with this case, worked very hard with everyone, said, okay, let's see what this is, let's see what this code violation, got emailed, each one got mailed, asking for the request of everything that needs to be done with this property. Since then, since our involvement, my involvement in this with Victor, everything has been up to date, has been worked on, in a timely manner, the best, sometimes it would take a minute because if he had, like the fence situation or the gutter situation, because that did take time because we were told that we needed to get a permit for that. And, looking into that was like, we don't need to get a permit. Some stuff should have been grandfathered in because of the year of the property or something, but we never had to get a permit. So that took up time holding up, trying to, research, like, okay, well, we need to get a permit, but then now we don't need to get a permit. So some things did take a minute. It did. But as of today, everything is compliance. If you look at the property, Victor done very well getting it, up to par.
No, and I understand, and you wouldn't be here if that wasn't the
No.
case, right? So I understand that.
Do you want to?
Excuse me. may
I mean,
say
it's not,
something?
yes, sir.
Oh, yes,
Again, let me get you get closer to the microphone.
you said this, they started finding this 2010. I never got notice of this because it was probably going to the other, company, property holder. Because
Well, one
sooner
of
I
the
got
case-
notice of it from Mr. Watkins, that's when I started complying. That's when I started really noticing because I never got any kind of notice. Only notice I got is from him when he talked to me. He said, this what's going on, and we talked. But other than that, 2010, I never got notice because nothing wasn't coming to me. How did
Magistrate?
the deed was set up. So I didn't get anything on that until I spoke to Mr. Robert Watkins.
Okay.
Magistrate, case ending in 347, went to hearing on April 6th of 2011. On that date, when magistrate issued the order, the note there is Victor Dove present.
Okay.
Maybe he didn't get notice, but somehow he knew about this case. And notice is not something I looked into, but it does say in the notes, certified mail sent, certified mail received.
Okay.
And signed.
He's saying that yes, you came to a hearing.
All right. Any final comments from the applicant?
I'm sorry, what was that?
I'm asking if you have anything else you want to tell me.
Okay, unless you do know.
No, I don't recall that.
I'm here, to request for the company and for Victor for, a substantial reduction on this. Again, we took care of the ones that from 2010, the almost 3,000 that he has paid in the fines and all of that, and then worked on the property. So I tried to work, as soon as I was aware of all of this, main thing is we worked on this. And, took a couple years to right now, from 19 to now, but some of the stuff, no, before us, before Equity Trust, no clue about it.
All right. Well, so it's not irrelevant, but the 2010 case with a $750 lien is not significant.
But not that.
I will reduce that to $100, just so that there's a conclusion to that case, payable within 30 days. On the other case, I've listened to all the arguments about legal ownership and all of that. There's no, regardless of legal ownership, you know, I don't think there's any question, sir, that you've been involved with the property since going all the way back. You were at the code enforcement hearing in 2011. Regardless, these are significant liens, and even the city acknowledges that there should be a significant reduction. I'm going to reduce, so this is the split order case. There's two, and there are actually two separate liens? Is that
Yes,
how-
sir, two separate liens from the split order.
All right, they're both almost identical. They're both, one's just over, one's at 240,978, the other's 242,925. I'm going to reduce each of those to $7,000, so that's a total of $14,000 plus the 100 from the other case. I'll give you 12 months to pay those. Okay, thank you very much.
Oh, I have a question. The one, can I ask real quick?
Pardon me?
The one for the boarding or the windows and all that, this here though, he paid, all right, so we received.
Ma'am, I've made my decision.
Oh, no,
I've
no,
given
no,
it-
that's fine, no.
I've got so many more cases.
I understand that,
I
but-
don't have.
okay, so who do I
I've
ask
given-
then?
I've-
Because I think
I've
we've
given
already paid
everyone a
that.
full opportunity to tell me everything you wanted to tell me. Everyone said they said their piece. I've entered my order. I will sign that order. We need to move on to the next
Okay,
case.
I guess we'll
Thank
speak
you.
to them, because we paid something already.
I'm sorry, Magistrate, how many days did you say in that?
Beg your pardon?
How many days did you give for that?
12 months.
That's it?
Yes?
All right, thank you.
Thank you.
Other matter number 9, case number CE 1907036, case address 946 McIntosh Street.
I will apologize again. What's the address, Kristen?
Good afternoon. It's 946 McIntosh Street.
Okay.
Agenda item number 9 on the other matter agenda.
Okay, Magistrate, this was actually continued from 6 of 17. I don't believe you were the magistrate for that. I think that was Wagner.
Okay.
At the time, there was a question of unity of title because there were two different liens. The city has agreed with their contention and is releasing the lien on the adjacent parcel.
Okay.
That's not in front of you today. I'm just giving you the background.
Okay. So whatever you guys were arguing about the
Okay.
last time has been resolved, and now we're down to,
So, case ending in 020 for 940 26th Street, 11/4 of 20. Fine started 1/4 of 21, ran for 99 days, total $24,750. $250 a day, date of compliance 4/13 of 21. This is the same owner. Our understanding is this with the adjacent parcel is under contract for $310,000. Yes.
You're reciting 940 26th Street.
Am I in the wrong one?
Yeah, we're on 946 McIntosh. Which
Oh,
is,
my Lord. Disregard everything.
okay.
First time for everything. Wrong 946. Okay, let's try this again.
Thank you.
Case ending in 386, 946 McIntosh. Date ordered 9/18 of 19. Fine started 10/4 of 19. Ran for 529 days. Total $52,900. $100 a day. Date of compliance 3/16 of 21. 15 cases under same ownership. Mitigation is the estate was unaware of the lien and COVID issues, but this was cited in July of 2019, which certainly predated COVID. And those 15 cases were cited prior to that. Basically, it was another city-managed property. I'm assuming under the prior owner who's passed. It's now in the estate. The city's asking for 50%.
How much, 50?
50.
Thank you. All right, yes, sir.
Yes, sir. This property originally belonged to my father.
Can I get your name and address?
Oh, sorry. Nelson, first name, last name Tamargo, Tamargo.
All right, and this was your father's property? you told me?
Originally, it was my father's property, who then was, after he was deceased, he willed it to my mom. My mom passed away during COVID, as well as my daughter, which created a lot of turmoil. We were unaware. I mean, I know you hear this every person that comes up here, but I honestly can tell you from the bottom of my heart, I was unaware of it. When the reason that I found out that this was an issue was there was a new code violation. When I responded to that right away, because the code violation officers sent an email, and I responded immediately, met the enforcer there. We went through the property and then found out that there was a lien on the property, and I was unaware of that. My father passed. When he passed, he had dementia, and then my mom passed at 94, so we have somebody who was a tenant there, and whatever was sent there, we never received, and I'm sorry for that. In the meantime, I've tried to comply with everything that they've asked me for.
Okay, thank you, sir. Mr. Posner?
Sorry for your loss, sir.
Thank you.
Both of them. The city certainly has no dispute with any of that. The issue arises that it was the estate responsible for it, and clearly a city-managed property with 15 cases prior to this lien case. I'm guessing, just guessing, that the health issues might have something to do with the lack of compliance at that time. But it doesn't reduce the city's ask.
Okay. Any final comments, sir?
No, I understand his position, and I respect that. I just, from my perspective, I did everything I could as soon as I could.
All right.
He has certainly been cooperative every step of the way with this lien reduction.
Thank you.
All right, thank you for that. All right, well, based on what I've heard, we have almost a $53,000 lien. I will agree to reduce that to $8,000 payable within 90 days. Can you do the 90 days?
Yes, sir.
All right, thank you, sir.
Thank you. Thank you very much.
Other matter number 3, case number CE 19020313, case address 3608 Washington Road.
You couldn't call the one I already started? Kidding. When you find out if they're here by 4026th Street. Find out if they're here by 4026th Street. Case ending in 313 for 3608 Washington Road. Date order 7/17 of 19. Fine started 8/1 of 19. Ran for 581 days. Total $145,250. $250 a day. Date of compliance 3/4 of 21. City is asking for 25% instead of the 50% it normally would based on the size of the lien. And the only mitigation given is they didn't receive the notice. The inspectors from the building division were not able to be here at the hearing itself. I do have an email from the chief plumbing inspector who testified at the original hearing that notice was due and proper, certified regular mail and posted to property, as well as a picture of the posting to the front door. I see that. And the stop work order. Sorry, and the Papa sheet.
All right.
One more thing, Magistrate. This is a prior owner applicant, the same owner that the lien originated with.
Okay. Yes, sir.
Hi, my name is Jack Owen. I'm an attorney for the applicant Windjammer LLC. That's the prior owner. As far as we know, the applicant has now completed all the work that was necessary for the permits. The applicant did not receive actual notice. I know that they say certified mail was sent. Applicant never received it. Didn't see any of the posted notices on the property. Had many interactions with the inspectors. No one said to her that she needed some permits. She applied for and did receive a number of permits. And nothing came up about this action. None of her subcontractors were aware of any violations. So she never really got notice until we were selling the property. And then the lien was filed in March of 2021. I believe the problem deals with not getting permits on plumbing situation. And the plumbing, we got a full plumbing permit approval and final sign-off in 2019. So there's a lot of confusion as to what permits were needed. She did, once became aware of everything, did apply for all permits that she was aware of that she needed. I believe the applicant also has some more information she would like to share with the court.
Okay.
Well, thank you allowing for me to be heard.
Let me get your name.
Oh, I'm sorry. I'm Andrea Carter.
And how are you affiliated with the property?
I'm the sole member of Windjammer LLC.
Thank you, ma'am. Go ahead.
Your Honor, I'm not somebody to blow off a permit request or something. I filed a number of permits on this property and a number of complicated plumbing permits. So I really did not understand that this was out there. I had no knowledge of this. If I had, I certainly would have rectified it immediately. I do want to note that the plumbing matter at hand, I believe, was actually that the existing sink was replaced by a new sink bed, and the plumbing that was then connected to the dishwasher needed to be at a different elevation. So this is not a life safety health crisis, but rather, I believe, just a true confusion. I was on the property a number of times during inspections, and at no time did the inspector say, oh, and why don't we also inspect this other matter? So I really, truly did not know, or I would have done something immediately. Again, I spent close to $500,000 of renovations on the property, pulled a number of permits, and I would never just have blown this off. So I'm sorry for the confusion, but certainly not intended in an ill way.
All right, thank you, ma'am. Anything from the city?
The city doesn't dispute whether or not whether or not there was any confusion, whether or not she received the actual notice. It just stipulates that it was properly sent and posted to the property. There were a number of permits that were issued. My understanding, having rewatched the original hearing, is while inspecting our other permits, they found work that exceeded the scope of permits issued and posted the stop work order. I guess that would be between Ms. Carter and the contractors that were there with the inspector at the time, whether or not they bothered to mention it to Ms. Carter. We're not questioning her intentions, but that doesn't mean the original case is invalid.
I respect what you're saying. I hope to not be executed over a plumbing matter that was certainly not going to hurt anybody. And I, again, have paid a lot of money for permits and worked really hard with contractors to see this project completed.
All right, thank you. Anything else from the city?
No, sir.
Any final comments from the applicant?
I said it. I don't want to take up your time, but thank you.
Okay. So in this case, we have a $145,250 lien. Based on the testimony that I've been presented with, I'm going to agree to reduce that to $10,000. Can you pay that within 90 days?
Yes, sir.
Thank you.
Thank you for hearing me.
All right.
Thank you, Your Honor.
Thank you for your, thank you.
You're welcome.
Other matter number 6, case number CE 15050862, case address 623 33rd Street.
Administrator, if I can have just one moment.
Of course.
same one, okay. Just one matter of point. Kristen, you can pull the other item off there. 940 26th Street, the one that I accidentally started, you can pull that off the agenda. It's completely canceled. Sorry, Magistrate. Case ending in 862 623 33rd Street. Date ordered 8/5 of 15, fine started 8/21 of 15, ran for 1,903 days. Total is $95,150. $50 a day. Date of compliance 11/5 of 20. This is a new owner. The second application actually with the new owner. First time around there was an open building case. So we've had at least one case under the new ownership. City's asking for 30%.
Yes, sir. Go ahead and tell me your name and address, then you can tell me about the request.
Yeah, Damien Barr. The address is 623 33rd Street, West Palm Beach. Yeah, we purchased the property with the liens attached to it. I think it was landscape. They can see the trash cans and whatnot. We knew what we were doing when we bought the house with the liens. We cleaned up the house, have done new landscaping, and have fixed the house up. So we're requesting for the lien to be reduced to hopefully an administrative fee.
Do you have a idea of how much you invested into the property in terms of renovations and
yeah, it's
that sort of
roughly about $30,000.
All right, anything else, Mr. Posner?
And I do have some like before and after photo. I don't know if that makes a big difference of how we bought it.
We have no objection. That's up to the magistrate.
Yeah,
we know
I'm happy to take a look.
Yeah.
He has pictures of the after already anyway from the inspections.
Yeah, I know the property has been brought into compliance. Yeah, you did a good job. That looks really nice. All right, for the record, there's 2 color photographs on one page that will be made part of the record for this case.
Okay, so our understanding is purchased for $72,005, put in $30,000, currently under contract for $249,000. City's ask is 30%.
Okay. Strikingly similar. All right. All right, anything else you'd like to tell me, sir?
No, sir. Just as I said, we're respectfully requesting administrative fee. We weren't the reason for the liens in the first place, and we just cleaned it up.
Okay. Yeah. Thank you very much. So in this case, we have a new owner with a $95,000 and change lien. Invested some money, fixed the property up. Based on what I've heard and the testimony for this case, I will agree to reduce that to $3,000. Can you pay that within 30 days?
Yes, sir.
30 days.
Thank you very much.
All right. I think that's it for the 11:30 agenda. All right, we've been going since 9 o'clock. I don't know what, the officers who are going to be testifying are able to come and go, but you guys haven't had a break for lunch. What do you want to do? You want to take 30 minutes, grab some lunch and come back? Or do you want to take 5 and stretch your legs and then push? I'm happy to do either way. I don't want to deprive you of a lunch break, though.
Yeah, like at least 15 minutes.
Okay, so it's 10 minutes to 2. Let's come back at let's try and be back on the record before 2:15. So let's try for 2:10, and we'll go off the record.